Good morning. Who is Good morning, Mr. Pistorius.
Good morning, Judge. Good morning, Judge.
Morning.
Pleased to meet you.
Yes, and you too.
Not expecting you.
You were not expecting me.
No, I was under the impression it's the Judge President who's going to entertain the matter. But in any event, pleased to meet you. I'm Senior Counsel from the Pretoria Bar.
Oh, nice to meet you, Mr. Mpashlele. I see you're on as well. I'm not sure. Your face looks familiar. Have you appeared before me here in Bloemfontein before?
Yeah, I was in Bloemfontein sometimes back. I think,
yes.
Yes.
You might have appeared, although, as I said, the face looks familiar. Thank goodness we don't have to wear masks today. Because I never recognize anyone with the mask on. All right, and we have Ms. Rustov.
Good morning, my lady. Mandaline Rooster from the Johannesburg Bar.
Yes, good. Yes, nice to meet you. And are we waiting? We're still waiting for somebody else? I'm not sure who else we're waiting for. Let me just see. Okay.
I think 6 and 9 respondents.
Yes, I'm just trying to figure out who is appearing for them. I've got, when they come, then we'll discuss the order in which we're going to hear things. And then, of course, there's a few housekeeping matters that we've got to sort out before we start. Let me just see who's on record for... Okay, Advocate Rustov, you are for number 1, 2, and 3, not so?
1, 2, 3, and it's also either 13 or 12. Gloria.
I know. It's a hell of a lot of confusion because I was reading the papers and she describes herself as number 13, and then I see in other places it's number 12, and so
yes, I'm not sure. The notice of motion, she's number 13, and then on the court order she's number 12. So there's some sort of confusion, but it's Gloria Cosa that I'm also.
Okay, yes. So those are the ones. Okay, so that's you. Then, Mr. Pistorius, you were for number 4, 5, and 7, right?
7, my lady. Correct, my lady.
Okay. Mr. Mpashlele, you were for?
The SIU.
Yeah, you for the SIU, correct. I don't know who was going to appear for the other respondents.
Maharaj.
Say again?
I think it's Maharaj.
Is he appearing in person for them? There's no counsel involved. Because I know for number 6, he's on record. I've got the president sent me some email correspondence to say that Mr. Miraj is on record for number 6. I don't know about number 9. Does anybody know anything about number 9?
It's also Mr. Maharaj.
Okay, and the number 10, Mr. Ramatsekisa. Does anyone know anything about him? He's also an employee of the National Lotteries Commission, right?
Yes.
Okay, because I'm not sure who's going to, because it doesn't look like the commission itself is participating in these proceedings. And then, of course, there's number 11. We've not heard anything from number 11 and number 10, so I'm assuming that they are not participating in these proceedings. And I think other than answering affidavits in the reconsideration application from number 6 and 8, I've not really heard anything further from them. They've not filed heads or anything that I'm aware of. See, the other challenge that I have is because things have been mailed to me or they've been couriered, not everything has reached me. It's up until midday yesterday, I was still receiving documents. So just bear with me. Sometimes there's certain things said in the heads and it appears, that I don't have a document here or there. So, but we'll try and cross that bridge when we get to it. So I don't know if it's only the three of you then that's going to be here. Because I understand that the secretary at the commission, at the tribunal is on study leave. So I haven't been told who the stand-in is that will be controlling the recording and stuff. So I don't know. I can see somebody called Inqaba Yokulinda. Is that somebody from the tribunal? Oh, good. All right. What is your first name? Is it Mr. Mangana? Okay, great. I'll just let my secretary know as well, just in case there's a problem, then she'll know to contact you. Good. All right. Is that all then, Mr. Mangana? Is there anyone else we're expecting? I hear that Mr. Miraj was supposed to be joining us. I imagine he would, because the president has sent me some correspondence between him and the SIU. I'm not sure if you're aware of it, Mr. Mphahlala.
Yes, I think there are some discussions between the SIU and I think Maharaj in respect of the Magog Hotel, wherein a draft settlement we're busy trying to tweak it, but simply there's going to be a settlement wherein he will be paying certain amount of money and then he'll be released from the preservation order. Okay. So
but you haven't heard yet.
Yeah, but it's in the final stages. Maybe that could be the reason why they're not here. I'm not sure.
Right.
Yeah.
So because I don't want to. Oh, we seem to have lost Mr. Pastorius.
Yes, Malay.
Oh, yeah, there you go.
I can hear you, Malay.
Yes, your picture's frozen.
Yeah, I don't know yes, it seems to be getting back onto online.
Yes, I can see you and I can hear you too. All right, good.
Thank you.
Yes, I see that it is just gone 10 o'clock. So should we start or should we rather, I don't know, Mr. Mphahlala, if you're able to establish if Mr. Miraj is going to be joining us?
I'll request my junior to try and contact him. And maybe if you can be given maybe 3 to 5 minutes.
Yes.
Let him try and see if you cannot get hold of him.
All right. Well, while he's doing that, maybe I don't think it's going to be out of order if we start discussing, the so-called housekeeping. As I all right. Let's see. Yeah, what I was looking at, well, as I said, one of the things I needed to clarify is the situation with respondent number 6. So we'll wait for your junior, then Mr. Mphahlala, to come back to us. And then maybe I must just address myself to you, Mr. Mphahlala. The confirmatory affidavit of Arlington and Chwe to the replying affidavit in the reconsideration application, SIU's reconsideration application. The replying affidavit speaks of a confirmatory affidavit by Mr. Chwe, who did the examination of the bank statements of the 4th and 5th respondents and found, you remember he was saying that at the 10th or 12th of March, there was a positive balance of 1,900 some odd. And then he went further on and then listed the expenditure out of those accounts or that account. But I don't have it. As I said, it could have been filed, but because a lot of stuff that came to me by courier, the hard copies, didn't have most, well, not most, but a lot of the documents that ought to have been there. So those were emailed to me. So I'm just not sure if maybe Ms. Rostov and Mr. Pastorius, you can confirm whether you have that in your bundle or you see, I don't have access to case lines. That's the problem.
That is just what I was going to propose on case lines. all the relevant papers are indeed uploaded. So, but I can confirm that my bundle is complete.
Okay.
Yes.
So it just obviously is a question of them not having forwarded it to me because it's on case lines. I know there's hundreds of documents.
Yes.
So as long as you're happy at some stage, Mr. Mpashlele, perhaps you can have that sent to my secretary.
I'll do
and I'm quite sure that what's in the confirmatory affidavit is in fact what's in the replying affidavit. But I think just for sake of completeness, if that can at some stage be sent to me, please. Right. 06 on the case condemnation. Oh yes, and then the other thing is, in the case of the first and second respondents, you asked for condemnation for the late filing of the heads. Was there an affidavit or something filed? Because I don't have it.
Yes, my lady, there was a complete application, a formal application filed.
It was a substantive application.
Yes, my lady. It was filed on the same day as the heads of argument was filed. It is uploaded onto case line, so I'm not too sure why it wasn't also given to my ladyship.
Yeah, well, as I said, it's because Mpho's been on study leave, and shame the president has been running around like a headless chicken trying to sort out papers for me. And I mean, that's in between her own work. So she's had a bit of a challenge as well. So it's possible that it was just omitted. I don't have that affidavit or that application. I just from your heads, I gathered that there must have been an affidavit or an application. So that was the query. I don't have that. So perhaps if we could just make a note, maybe Mr. Mangana, you can also make a note and perhaps send those to me or to my secretary, Liesel, because Mpho has been communicating with her. Yeah, so it's the affidavit of Mr. Arlington and Chwe, which is the confirmatory affidavit to SIU's replying affidavit in the reconsideration application. Then it's the condemnation. I think one of the other respondents as well, was it not number 13, Ms. Rostov? Also.
Yes, my lady. So the condemnation application was one document for 1, 2, 3, and 13.
Yeah. Okay. So if that can be sent to me, please, as well. Let me just look at reconsideration, applicants' heads and reconsideration.
I've just been notified by Mr. Maharaj that he will not be joining us. So to indicate to you, it appears that he will not be joining the application or participating at least in this application.
So it means, and it's just the three of you. I don't think there's anybody else joining us. And as I said, apart from answering affidavits for number 6 and 9, there's no other movement from them. You know, there's no heads or anything that I'm aware of. That is why I said, and the other thing that hasn't been sent to me is the case management minutes. So I'm picking up pieces from heads and from affidavits as to the dates of these case management meetings. I don't have, Mr. Mangana, if you could perhaps also look at that, send that to me, please. Okay, yeah, so those are things I don't have. I'm just looking at, there's a query I have here about paragraph 6.11 of the applicant's heads in the reconsideration application. Let's have a look. There we go.
Okay.
Right. Oh, yes. Mr. Mpashlele, there was a reference to a special tribunal judgment in your heads for the reconsideration. I'm not sure how to access that. Is that uploaded on case lines? Because you've referred to it in your heads, but I'd like to have a look at it.
My junior will upload it on case line, Malita.
Okay, and then perhaps it can also be sent to me via the tribunal office.
We'll do some on it.
Okay. All right, I think those are basically the queries I had. Then I think we need to move on with regard to how we can deal with this. There's 3 applications that I see that's before me. The first one is the extension, I call it the extension application, where SIU is applying for the date to be extended so that they can bring the review applications at a later date. And then there's the reconsideration application, which is the big one. And then there's a decision application by the 7th respondent.
Malid, there's also a striking out application.
Oh, yes, that's right. That is the 4th and the 5th, the striking out application. So that's basically 4 applications. How are we going to deal with this? I mean, just for purposes of going forward, we really have very little time. It's only one day. I've read all the papers that have been sent to me. I've read all your heads. And what I normally do when I know I've got, lengthy matters, is for you simply to highlight, and we'll deal with them one at a time, the application. I think I'm proposing that I hear all of them today and then start off with, obviously, when I'm doing my rulings, is start off with the extension application, because that could be dispositive of the whole matter, depending on which way I go. But if you have other ideas, you can possibly tell me. Mr.
Lady, I have in the issue of my learned colleague for the applicant, and I propose that we deal with the extension application first, and if to get the ruling or judgment on that aspect, because as you correctly put, should the extension application of the SIU be dismissed, that
you're breaking up, Mr. Pistorius. I can't hear you.
The reconsideration and
I'm not sure. Are the others able to hear him?
Normally, he's breaking terribly.
Very bad. I just heard extension application, and then I heard reconsideration application, but we can't hear you, Mr. Pistorius.
He seems to be frozen as well.
Arguments.
Oh.
There we go again. Can you?
I can hear you. Oh no, you're breaking up again. A very robotic picture, robotic movements.
I will try and maybe use the laptop. Will you give me a minute to just change my position? It seems
certainly.
Like can you hear me now, possibly?
I can hear you.
Can you just indicate if you can hear?
I can hear you.
Should I proceed then? All right.
Yes.
I was proposing that we deal with the so-called extension application first, because should the extension application be dismissed, that would make the remainder of the application academic, in the sense that the matter should stand and fall with the main point in limine regarding our viewpoint that the order has lapsed, and as a consequence that the applicant's application should be dismissed and that they should reinstitute proceedings if they so wished. So I discussed that with my colleague for the applicant, and he holds a different view. Maybe if you can indicate what your preference.
You're breaking up again. I can't hear you.
Is it the same? Let me just move to a different laptop and see if
I think that might be better. Yes, if you could try.
Okay. So, unmute. Sorry for this. It seems like my.
Mr. Pistorius, at times when two devices, if they are in one room, it creates a problem. Maybe you should switch off one of the devices.
I'll do so. Thank you, colleague. I will proceed on the other one. Can you all hear and see me now?
Yeah,
Yes,
much
we can
better.
hear you, but we can't see you. And I see Mr. Maraj has joined us as well. I was under the impression you were not going to join us, Mr. Maraj.
Good morning, my lady. Lady, in fact, I didn't even receive a link for today's hearing, but just to place on record, my lady, that insofar as the sixth respondent is concerned, we've virtually settled the matter. Well, we have settled in principle with the applicant, and I merely wanted to inform my lady that a settlement agreement has been drafted. There were certain amendments that needed to be made, which have since been made. My client has signed it, and we're in the process of sending it through to the SIU in the next few minutes. So to that extent, my lady, there's no need for us to participate any further in these proceedings. It's academic insofar as we are concerned, and I asked to be excused from the proceedings.
Yes, I was under the impression that you weren't joining, and that was by agreement with the SIU. But most certainly, because that was the impression I think Mr. Mpashlele had a few minutes ago as well.
Absolutely. No, the matter has indeed been settled between us.
Good.
Thank you, my lady.
Thank you, and thank you for letting me know. Yes.
Okay, may I be excused, my lady?
Yes, absolutely. Thank you.
Okay.
All right, let's get back to the way forward, Mr. Pistorius. So you suggested that we deal only with the extension application today. Is that correct? Oh, he's disappeared again.
No, he's still there, my lady. Yes.
Ah, here we go. Yes.
I can hear and see you. I hope.
Yes, I can hear and see you clearly now. You're not looking robotic anymore.
Well, I hope that helps as well. I was proposing that we deal with the extension application first, and possibly if we can get a ruling or a judgment on that, because the remainder of the application itself might become academic or moot should the application of the SIU be dismissed on this point regarding the lapsing or not of the order.
Mr. Stoff, let's hear you, and then I can ask Mr. Mpashlele.
Thank you, my lady. My lady, in per se, we, as the respondents for 1, 2, 3, and 13, didn't oppose the application for the extension. However, my lady will see in my heads of argument, I did address the issue of lapsing of the order, because the order was only for 30 days, or for the SIU to institute review proceedings within 34 days, which lapsed then on 29 March. So that portion was addressed for the lapsing of the order, and I'm in agreement with my learned friend, Advocate Pistorius, that we should first deal with that, the extension / the lapsing of the order, because if the court should find in our favor, then there's no further argument with regards to any of the other applications.
Mr. Mpashlele?
My lady, all the papers are before the court. The Rule 14 application, rescission application, striking out application, and the reconsideration application. And your ladyship has also indicated that he has also read all the papers. It will be expeditious in dealing with this matter, my lady, that all the application be dealt with. And because if not, my lady, it means that should your ladyship then grant us the extension, it will mean we'll have to come back and then argue the other 3 applications. While it will be much more convenient if all this application are argued. And if your ladyship is not with us on the Rule 14 application, that's the end of the matter. Then it doesn't have to deal with the others. But if it's with us, then we would also have the opportunity to also deal with the other application and would have addressed your ladyship on those applications. Those are my submissions, Mani.
Yes, that for me was a concern when I was considering how we're going to go forward. And time is also now a factor because the matter is dragging out. And I'm just a bit concerned if we do one application, then we adjourn for a ruling, when do we reconvene? Because everyone's availability is always a bit problematic. And that for me was also a concern. And as you know, I don't sit full time on the tribunal, and I would like to start and finish matters that are allocated to me in the most expeditious way. I'm in agreement actually with Mr. Mpashlele that we hear all of them. All the papers are here. I will obviously, when I'm starting my deliberations, will deal first with the extension application, because that, as I say, depending on which way I go, can be dispositive of all the other matters. And then, you take it from there. But at least all the arguments are before me. Let's assume I decide I'm going to grant that application. Then at least I have all the other arguments and papers before me, and I just simply move on to decide and to write rulings or judgments on the other applications, which I think would probably be the most time-efficient way to do it.
As the court pleases, Mali.
Court pleases.
Yes.
My lady, we are the applicant on the Rule 14 application. I think maybe we should start.
Yeah, give me one moment, Mr. Mpashlele. I just want to record that.
As the court pleases.
All right, then. So all the applications will be heard today. Then it just brings me back to the initial point that I raised in terms of how we will take it forward. As I said, I've read all the papers. I've read all the heads. I don't think that the missing documents, that the affidavit of Mr. Nchwe or the substantive application for condemnation is too serious at this point. I've been able to pick up from the heads, what the situation is. And I think, as long as I get it, say by the end of the day, it should be fine. Whatever else is missing. So whatever's missing it's not going to hamper our ability to hear. As I said, I've read all the papers. My proposal is we start with the extension application, move on to the reconsideration application and the striking out at that time, and then we finish with the rescission application.
As the court is valid.
Yes. So what I would propose then is that you point out what is it in the heads you want to highlight, or if there's anything you wish to change or amend it in any way, that will then save us time. So if I give each of you 15 minutes, is that enough per application?
That should be sufficient.
Yeah, 15 minutes to address, and then perhaps 10 minutes for reply.
That should be sufficient, Malady.
That's fine.
Okay, good. So, Mr. Mpashleli, you will then start off with the extension application.
As the court pleases, Malady. Malady, I'm quite aware that we start with the Rule 14 application, the extension application. But before I do that, there's just only one thing that I just want to refer this honorable court to in the reconsideration papers, which I'm going to use to substantiate my arguments in the extension application. I want to refer your ladyship to the founding papers, that is on 00153. In terms of the case line number.
Let's go. I'm not on case lines, and the papers that were sent to me, unfortunately, were filed in a way that simply didn't make sense to me. So let me tell you what I've done is I've separated each application, and so in the reconsideration application, just refer to the relevant document. So if you are referring to the applicant's founding affidavit, just say that, because I've got it marked like that. Similarly, with all the other applications, I start from the logical, the founding papers, the answering papers, the replying papers, and the heads in each one. So if you just refer to the document itself and which application, then it's easy for me, because I've just rearranged the entire order. It flows more logically for me.
As the court pleases, my lady.
So you're looking at the founding papers in
the founding affidavit of Mr. Godsafe Ngobeni.
Yeah, that's in the reconsideration application.
The reconsideration application.
Okay.
That is on paragraph 16.6 and 16.7, my lady. Those are just short paragraphs, my lady. I can just read them into the record.
Yes.
16.6, it says, on 3 April 2018, UNICAS paid an amount of 806,550 Rand to Karu Software. The SIU is still awaiting answers from the members of Karu Software to confirm the reason for this payment. Further investigations are ongoing in this regard. That's the first point. And 16.7, the SIU also says on 13 March 2018, an amount of 2.5 million was paid out of the account of UNICAS Pty Ltd into the account of cousin Herzog Attorneys. Further investigations are still continuing in respect of this transaction. So, my lady, we are dealing here with a matter which investigations have not been completed. And as a result of that, that in itself causes that as the investigation in respect of particular transactions get completed, that applications for preservation orders should then be brought. Now, I can reliably inform this honorable court, my lady, that an an application for a preservation order has already been filed with the tribunal in respect of the 2.5 million that we've spoken about, that I've referred to in 16.7.
Okay, just give me a moment. Okay, yes, you may proceed, Mr. Mphahlele.
As the court pleases, my lady. My lady, this application was brought in terms of Rule 14. And my lady, I want to refer your ladyship to Rule 14 of the tribunal's rules. It makes reference to extension of time, bar and confirmation.
Yes. Well, it's been quoted so many times in the papers, I can almost read it off by heart.
Indeed, my lady. And we submitted that the reasons why we are seeking this extension, my lady, or revival of the order, if it has lapsed, is based on the fact that there's an ongoing investigation, and once the investigation has been completed, there's a need for those parties to then be brought on board. If your ladyship could refer to paragraph 1.4 our heads. That's the reasons why this application is being opposed by.
When you say your heads, are you talking about your heads in the
extension
consideration or the extension application?
Extension application.
Give me a moment. I've just got to open to it. All right. You say what paragraph?
Paragraph 1.4. We state exactly what is it that the first, second, and 12th respondent reasons for the opposition.
Yes.
I think it's the 4th, 5th, and 7th who are opposing, my lady.
Yeah.
It has now become apparent during these proceedings, and maybe in the heads, that similarly the 1st, 2nd, 3rd.
They've all jumped on now.
Yeah, they're now
jumping via the heads.
They're now jumping into the bank. Okay, we submit. There's no proper opposition from the 1st, 2nd, and 3rd, my lady. In that they have not filed papers in that regard, and on that basis, we even though they are saying that even their reasons are the same as what is proposed by the 4th, 5th, and 7th. So I will deal with the issue of lapsing. The reasons are there, my lady. Paragraph 1.4. They're saying, firstly, they argue that the matter is not urgent. And secondly, they contend that Rule 14 is not competent under the circumstances because the order of the 14th of February has lapsed, or is incapable of being extended or revived. They say it is incapable of being extended or revived, my lady. My lady, we are saying this is not correct, because if one looks at Rule 14, it grants this particular court that power and authority to decide as to whether it would want to have the particular any rules extended, or if you look at 14.3, after the discharge of Rule 9 by default, the tribunal may also on application revive it.
Well, on that point, because I've read all the arguments around that, but on the point of 14.3, the 4th to the 7th respondents of 4, 5, and 7 raised the point that 14.3 does not apply because this is not a rule nisi that has lapsed. It was in the nature of a final order, and therefore the tribunal does not have the power to revive it. Perhaps you can address me on that, and what is your view on that?
My lady, it was not a final order. It was an interim order, because my lady would see what the order is saying. It's an interim order, in that the order states that pending the institution and final determination of the legal proceedings, the applicant will institute within 30 days of the date of this order for the review and setting aside of the decision by the 13th respondent to award funding to the first respondent, as well as the execution order granted in the review application. It is ordered in accordance with the provisions of Rule 24. This is an interim order, my lady. It's not a final order. And my lady, a final order doesn't lapse. For the mere fact that an argument is being raised that the order has lapsed, in itself substantiated the fact that this is an interim order. And therefore, we submit that Rule 14.3 applies in respect of this particular order. And my lady, even if you are wrong, my lady, I would want also to refer your ladyship to Rule 28. Rule 28, the first one, and I think this.
Sorry, Mr. Lela, give me one moment. I just want to record your argument in respect of final and interim order.
Yes, my lady.
Right, you say Rule 28.
Rule 28 states the following, 28.1. If a situation for which these rules do not provide arises in the proceedings or contemplated proceedings, the tribunal may adopt any procedure that it deems appropriate in the circumstances, including the invocation of the High Court rules. That's the first one. Sub-Rule 2, it says the tribunal may, in the exercise of its powers and in the performance of its functions, or in any incidental matter, take any steps in relation to the hearing of the matter before it, which may lead to expeditious and cost-saving disposal of the matter, including the abandonment of the application of any rule of evidence in order to achieve the objects of this act. Now, my lady, we submitted that. If your ladyship is with the respondent and regard that the interim order obtained has lapsed, what will happen is that the moment that order is granted, the next day the SIU will be before the court, my lady, asking for the very same order. Now, if that is the case, we submit that this court can exercise its own discretion in the interest of expeditious and cost-saving disposal of this matter, and either extend the interim order, and if it has lapsed, revive it for the purposes of getting finality of this particular matter. It is therefore in the interest of justice, Mali, that an order in terms of Rule 14 be granted. We have provided reasons, and the reasons are to the effect that there were investigations that involved the same parties in this matter and new other parties. And that application has been filed. And in that application, my lady, now we're dealing with the 2.5 million that went to the attorneys that we referred to in that reconsideration application. And
So
there are no other parties.
So what you're saying is those involve other parties than the respondents before us, and there's a preservation application that's now going to be brought. Is that what you're saying?
There's a preservation application that has been brought in respect, in respect of those respondents that are not part of these proceedings. That involves the 2.5 million that we have referred to in these papers for the
Which you say are proceeds of that 15 million or that
correct.
10 million that was sent to transferred to the fourth respondent.
That's correct, Malidi. So if your ladyship does not grant this application, the likelihood is that we're going to have now the other parties, as has been under a preservation order, and this one having been released, while the intention was to make sure that all of them are under a preservation order when we bring the review application.
Yes, thank you, Mr. Mpuhlelo. You may continue.
Yeah, lastly, my lady, all the parties now have filed their papers. They are before the tribunal. And the purpose of the preservation order was to ensure that the properties are not dissipated by the respondents. They have now had an opportunity to also file their own papers wherein they actually present their own defenses. So there is no prejudice in that. The prejudice will only be suffered by the SIU if ever the preservation order is regarded as having been lapsed and it's not extended. They will have an opportunity to ventilate. All the parties have the opportunity to ventilate all the issues before this tribunal. And that is even an opportunity that has been provided to now. Malede, I think I've just dealt with some pertinent issues relating to the Rule 14 application. I just wanted not to waste too much time on that and move to the issue of the reconsideration application.
Just give me one moment. I think I'm going to deal with each application separately so that I have the arguments following logically instead of jumping to the next application. So I'm going to give Ms. Ristoff a chance to speak because you are now for number 1, 2, 3, and 13 or 12, Ms. Khoza. Let's call her Ms. Khoza. I'm still very confused about whether she's respondent number 12 or respondent number 13, but I understand that there was an amendment somewhere along the line.
My lady, just one more point before Mr. Pistorius comes in. My lady, I just wanted to make point. We submitted that it is in the interest of the effective administration of justice that one composite review application be brought and not a multiple reviews, and which is what would happen in the event that the extension is not granted, or if the order is lapsed, if it is not revived. That would be my last submission.
Thank you, Mr. Mpuhlelo. Thank you, Mr. Stoff. Mr. Pistorius, I'm doing this, I'm giving Mr. Stoff a chance to speak because she's now representing the earlier respondents, and it just follows a little bit more logically that respondent 1, 2, 3, and 12 said this, and it, from a point of view of reading and getting my judgment sorted out, it just makes more sense. So we're not jumping over you in terms of rank and so on, if you don't mind.
Yeah, that's perfectly fine. Thank you.
Thank you, Ms. Risto.
Thank you, my lady. My lady, yes, the representative of the applicant already indicated that we have not opposed officially the Rule 14 application. However, my lady, in the interest of justice and from the papers itself, it's my respectful submission that the respondents, the relevant respondents, can raise the issue of the lapsing of the order for the following reason, my lady. From the papers itself, from the court order itself, my lady, the applicants were given this court order already on the 14th of February 2022, and in it, it specifically states that this order is pending the institution of the review application within 30 court days. This is an order specifically asked for by the applicants ex parte. They specifically committed themselves to the 30-day period. They specifically actually asked for a 21-day period, wherein the court at that stage even granted them more, a longer period to say 30 court days. Then 30 court days expired on or before the 29th of March 2022. Now, my lady will see from the Rule 14 application that a letter was sent to the parties and requested for the extension. This letter, my lady, was attached to the application as Annexure B. It's a letter from the Office of the State's Attorney asking for if the parties will agree to an extension of a further 21 days. The letter was dated the 31st of March 2022. Now, at that stage, the court order already, I submit, has lapsed. Already on the 29th, going to the 30th, that the order has lapsed. So they requested for an extension after the order has lapsed. The respondents 1, 2, 3, and 13 at that stage then indicated that they have no objection to the proposed extension of 21 days. The applicant then brought the Rule 14 application and specifically asked this Honourable Court now to extend the filing of the review application until the 25th of April 2022. Now, this is the application the applicant has argued today. That's the application filed for an extension. Wasn't filed, request for a revival. So the application in itself, it's my respectful submission, my lady, is defective because it asked for an extension of an order already lapsed. Then it asked for an extension for this Honourable Court to grant it until the 25th of April. That day has passed and still no review application has been filed. So this entire application in terms of Rule 14 brought by the applicant is defective because it asked for a date already expired, an application already not filed, the review. It doesn't in its application mention Rule 14 sub 3 because the Honourable Court also this morning asked about Rule 14 sub 3. It refers to a rule nisi. My learned friend for the applicant then addresses the Honourable Court to say that this is an interim order. But the rule refers to a rule nisi. A rule nisi is that there's a return date on the order for the respondents to show good cause why the order should not be made final. The court order granted on the 14th of February is not a rule nisi. There's no date, a return date, for the respondents to indicate why it should not be made final. So in that regard, there is no revival application. There is no rule nisi court order. So on the 29th of March 2022, the order as granted on the 14th of February has lapsed. And because it has lapsed, there's no need for any further applications to be heard in this regard, my lady. And the agreement by the respondents at that stage to not oppose a further extension was then sought wrongly because the order already lapsed. Now, my learned friend's argument also this morning that, especially when he referred to paragraph 16.7 in the consideration application or in the founding affidavit, and that's the reason, it still doesn't make sense, my lady, because there's still no review application. The fact that they brought another preservation application against other people in connection with the 2.5 million doesn't excuse them for complying with the order which they sought. And even till with his argument today, my lady, he has never addressed the Honourable Court as to when will this review application be filed. Because if he's asked the court for extension until the 25th of April, then at least the review application should have been filed in that period. It's still not filed. There's still no supplementary application to extend it even further if the order has not lapsed. So in summary, what the applicant asked this Honourable Court is to excuse them from performing in terms of the court order, to excuse them for not complying with the rules of the court. Because if the court will decide against them, well, then tomorrow they will bring another preservation order. But they simply can't comply with one order. So why should the court extend or revive or provide them any relief? Even with the referral to the other rule, it's just an excuse for them not to perform. They were the ones who approached this court in February 2020 on an ex parte basis. At that stage, if they knew that the investigation was so far from completion, why then at that stage proceed with an urgent application? Why proceed and ask the court for 21 days at that stage? Clearly at that stage, they were fully aware of the matter and the investigation, the extent of the investigation, and their willingness or their readiness to file a review application. My lady, that was 14 February 2022. Today is 6 June, and there's no review application.
Today's the 3rd of June.
3rd of June, yes, sorry, my lady. So there's still no 5 months later, 4 months later, we're still no closer to a review application. So if the court should grant them their Rule 14 application, then till when? Did they address that? No, my lady. So now they want to say that they are the only ones who will be prejudiced, but they don't think of the respondents, the prejudice they will suffer from hanging in the air with this application, not being final, no review application coming forth by the applicant, no indication from the applicant when this will ever happen, if it will ever happen. So the prejudice suffered by the respondents is severe, in that they have to wait for something that's not coming, for a review application that's not coming, for a preservation order with regards to assets, for a curator to have been appointed, and nothing is happening. As this Honourable Court already this morning indicated, this is matters that should be concluded speedily. This is not the case. So in that regard, my lady, it's my respectful submission that the order as granted on the 14th of February 2022 has lapsed. There's no proper application before this Honourable Court from the applicant for a revival, because they can't indicate that it is indeed a Rule Nisa order, or the extension was that application itself was done after the lapse of the order. So we'll at this stage ask this Honourable Court then to dismiss this application, the main application, on the basis that it is already lapsed, and to grant a cost order against the applicant in this regard. Thank you, Madam.
Okay.
Malady, I don't know whether I should be the one to reply before we go to Mr. Pistorius.
No, I think let's give Mr. Pistorius a chance, and then you can reply to both. Right. So we are dealing with the 4th, the 5th, and 7th respondents. Mr. Pistorius?
As the court pleases, my lady, I'm deputy to the court. The first submission that I would like to make is that one should have consideration, first of all, of the nature of the proceedings that served in front of ladyship, the president of the tribunal, when she granted the order in an ex parte urgent application. The first principle, in essence, is that an ex parte application, in general, goes against the grain of procedural fairness in judicial process, because the respondent obviously need not be for court, and as a result thereof, it strikes principles in law that it should be dealt with strict and limited time duration. So the first submission is that the applicants chose the form in which they sought the order. They chose ex parte proceedings without a Rule Nisa, affording the 4th, 5th, and 7th respondent an opportunity to answer to the application, and went further to rely on urgency, which we will later deal with, which was not properly addressed in any event. And the learned judge making the order simply made a final order with one rider or one condition, as alluded to by my learned colleague, Ms. Rustov, that within 30 days, the review application had to be instituted. Now, even in paragraph 11.3 of the order of court, the applicants were even granted further indulgence that should they seek further redress regarding extension of time, they are allowed and they may do so. Now, my lady, the applicants chose not to do that. In fact, the applicants failed to do anything. As we sit here today arguing the matter, which was ripe for hearing already on 5th of May, and only subsequent to that, the Rule 14 application, no review proceedings whatsoever has been instituted. So the principal objection to the lapsing of the order, which we will argue, is that it goes against the general grain of procedural fairness. It militates against constitutional fairness of a litigant, particularly the respondent, where the interest, in this case property at heart, are being abused. And should you allow further indulgence, it may lead, and that is what we will submit, it would be an abuse of power, and it would be draconic to the extreme sense of the word. The applicants simply chose the route that they proceeded with in this application, and if they cannot comply with their own order, then why must the respondents be prejudiced indefinitely to the liking of the applicants? My lady, I have, in my heads of argument, we have extensively dealt with what the meaning is of an order and
Yes.
and what an order means and the finality of the order. There cannot be any doubt that the manner in which the order was framed was subject to the institution of review proceedings. I submit that my learned friend's argument that they then would be, if we were to be correct in our order, in our arguments, they would simply be again in front of the Honourable Tribunal to institute new proceedings, and that would be detrimental to the interests of justice. Our argument is simply, so be it. If the applicants choose a particular litigation route and they do not comply with the order that they obtain ex parte without respondents of being afforded the opportunity to even answer to that on an urgent basis, then they should be punished with an appropriate cost order, which I will deal with later. More importantly, respectfully, my colleague dealt with his interpretation of Rule 14, and that the court, in the interest of expedition and interest of justice, may order an extension or revival of a order. His respectful interpretation is incorrect. Rule 14, 1 and 2, on a proper interpretation, my lady, only deals with the issue of condemnation of time periods as reflected in the rules, not with regard to the revival of a court order. So fundamentally, my learned colleagues' submissions are bad in law and should not be upheld. We respectfully submit that even the reference to Rule 14.3 of my colleague, with the greatest respect to him, governs a situation where a rule maza was discharged by default. And only when a real maza is discharged by default, then it may be revived on application. This is not the case in this application, my lady, more particularly for obvious reasons why we submit that the order was a final order. In that sense, there cannot be any doubt that the application in terms of Rule 14 is flawed, simply on procedural aspects. But more importantly, my lady, if I may then refer you, and I'm dealing with my heads of argument also for purposes in assisting the court regarding the good cause being shown, even if we are wrong that the application has not, that the applicant is entitled for an extension and or a revival. We say on page 8 of my heads of argument that the applicants has failed dismally to show good cause for revival or extension. The respondents who are supposedly to be added to this applications are not identified in the current application before your ladyship. There is no satisfactory explanation for the delay covering the whole period. And if I refer to whole period, first of all, the period when the order in itself lapsed on the 23rd of April, as Ms. Rustov already alluded to. No explanation for any reason why review proceedings has not been instituted. And lastly, against paragraph 38.3, we say that to grant this indulgence erroneously in law sought by the applicant will prejudice the respondents to the extreme, because their fundamental rights to property, to possess property, to deal with property, which is the subject matter of the preservation order in this instance, will be infringed upon to the degree of extreme prejudice. My lady, I've dealt with the explanation for the delay on page 8 of my heads of argument, where I alluded to the decision of Van Wyk versus Unitas Hospital, which is the guiding decision by the Constitutional Court regarding indulgence. And in this regard, it should be res ipsa loquitur that this matter became moot the moment that the order lapsed. The applicant had 6 weeks in which they were afforded the opportunity to launch the review application. Not a single word in the applicant's papers is preferred for their failure to do so. And more importantly, we say in paragraph 44 that the applicant's failure to explain the delay and to explain to the court what steps, if any, they were taken to execute the review application is non-existent. So until today, and still we don't know what is the reason for the delay. The suggestion that there might be other respondents to be added in a consolidated review application is a feeble argument at the peril of applicants or respondents before your ladyship whose fundamental rights are being infringed upon. We submit with the greatest respect that there is no indication by the deponent on behalf of the applicant when this so-called evidence or new evidence was uncovered, who these respondents are, how they are implicated, and more importantly, what part the applicants from launching the review application. As a result, we submit with the greatest respect that the applicants has not made out the proper case for the relief they seek, and particularly failed to address the prospects of success of this application should they be bringing the review application against this unidentified respondents. We say on page 10 of my heads of argument that the applicant failed to deal with the prospects of success of the review application against this unidentified respondents. They have not made any case out against this unidentified respondents. And as a result, even if my learned colleague is correct that Rule 14 applies, he has failed, or the deponent has failed, to show good cause why this application and your indulgence should be awarded. In the light thereof, we dealt extensively with prejudice on behalf of the respondents that I represent on page 11, and I need no reason to repeat that. It is before your ladyship, and as you indicated, you have read the papers. As a result, my lady, I must emphasize, and it must be a subject matter of this application in itself, that for the sake of expeditious process, the applicants came to court on an urgent basis, as I said alluded to, on an ex parte basis, and the respondents were given 2 days to reply, to comply with practice directives, which they themselves, that is now the applicants, simply chose not to comply with. And respectfully, we say litigants should be treated on equal footing. This submission I make on page 13 of my heads against paragraph 78. The perception that this honourable tribunal is an extension of the SIU can never be tolerated, even if the perception is not good in law or even wrong. To extend an order that has lapsed, which is trial law, cannot be revived. This is as simple as it is, my lady. And as a result, we say the tribunal may not arbitrarily exercise a discretion in favour of the applicant when the legal threshold was not remotely met. As a result, we simply submit that the applicant has failed to pass the evidential yardstick for such an application, and in that event, this application stands to be dismissed. And I respectfully propose regarding costs, if I'm called for to argue that costs must follow the result. And in this sense, I refer to you on page 14 of my heads, which was held by Tyndall AR as he was then, regarding punitive cost orders when there's an abuse of process, and particularly the direct directions by the order of this court and its dismal failure to comply with that. So as a result, with respect, we ask that you uphold our opposition to the application and dismiss the application of the applicants for further indulgence or revival or extension of the order.
With costs.
With punitive cost order with respect. That would include costs of senior counsel and junior counsel. Maybe I omitted to state when we came on record that I'm appearing with my junior counsel, Mr. Mattia. So, yes. So the application should be dismissed with cost of to counsel, and simply it means that the applicants should reverse their whole position, consider it afresh, and institute new proceedings if they then so feel, my lady. That is our submissions on the Rule 14 application.
Thank you, Mr. Pistorius. Right, reply, Mr. Pashlele. Mr. Pashlele, you may reply. Can you hear me?
I was muted. I was muted, my apologies. Maleda, I was saying, firstly, let me deal with the submissions that were made by my learned colleague, Ms. Ristov. Firstly, my lady, if your ladyship could see Annexure A, which is a list of the properties.
Annexure A to the order.
Yes, which are a list of properties that are subject to the preservation order. None of the properties of the first, second, and third respondent are a subject of that. None of the properties of the first, second, third, and 13 are a subject of that preservation order. So there's no basis at all for the first, second, third, and 13 to be and to be making the submissions that they are making before your ladyship, because their properties are not a subject of the preservation order. And secondly, they are alleging that there are no allegations for the revival of the order. My lady, I want to refer your ladyship to the founding affidavit in the extension application, paragraph 10.2.
Just a minute. Yes.
Paragraph 10.2. In the event that the order has lapsed, the applicant prays that same be revived for the reasons aforementioned. So there is a request for the revival of the application. And I just wanted to also make the following point, my lady. When this application was made, the reconsideration application had been set for the 5th of May, 2022. And on the 14th of April, after this application has been launched,
the reconsideration application was set for the 5th of May, right?
5th of May.
And
yes. And when the applicant realized that there's a need to have the extension, that's when the applicant requested an extension from the respondent, failing of which they brought an application in April. Now, on the 14th of April, a case management meeting was held. And in that case management meeting, it was then the applicant was then ordered to file the heads on the 28th of April, 2022. That is the reason why that had an impact on the dates that are in the notice of motion. Because the case, it was not anticipated that will then be required to file heads of argument way past the 5th of May, 2022. And the submissions in relations to revival, my lady, because my learned colleague, in respect of the first, second, and third, submitted that there are no number of days for which this application should be extended. If it is revived, my lady, it's supposed to be revived for the same 30 days because it's a revival of the order that was granting the applicants 30 days to file their own review application. Malay, then if I had to deal with the issue.
Just a minute.
Yes.
Yes.
Malay, if I now to deal with the issue and the issues that were raised by Mr. Pistorius, wherein he actually indicated that there's no procedural fairness because the application was brought ex parte. My lady, the order that was granted on the 14th of April made it very clear that the respondent, in terms of paragraph 12 thereof, notice of opposition and final further affidavit, the order said if any respondents or any other person affected by this order wishes to have the order reconsidered, he or she or it shall, on notice on the other parties, enroll the order for reconsideration in terms of Rule 12.9.
Wait, hang on. Which order are you talking about? From the case management meeting? Is that the one?
No, my lady, the order of the 14th of April. In the one that Mr. Pisto, 14 February, the one on the one that is being reconsidered now.
Yes, no, that's what I'm because 14 April is when you came.
This one is my apologies, my lady.
I thought there was another order I didn't know about.
My apologies, it is the order of the 14th of February.
Yeah.
And in that order, the respondent were informed of their right in terms of 12.9 for reconsideration. But they decided to wait until the 14th of March to bring that reconsideration application. And now the respondent are making allegations to say it is a procedural unfairness. The whole rule NISA was unfair. That cannot be unfair, my lady. They had an ample opportunity to respond. They're also making allegations that there's been an abuse of the property. I don't seem to follow that argument, my lady. I don't know how the property of the respondent is being abused. Abused by whom? Because it's just only subject to a preservation order. And they're saying the prejudice is indefinite. My lady, they are here. They are before this court. They've submitted. In fact, there is not even a defense to the allegations that we're making, and I'll deal with that when I deal with the reconsideration. There's no defense against the claims that they're actually the only thing defense they are raising is that the language of the act talks about something different. But I'll deal with that when I deal with the reconsideration. But there's no abuse of the process. My lady, there's an explanation as to why the revival is being sought or the extension has been sought. And that is also, my lady, your ladyship would find it in paragraph 3.3 of my heads of argument.
In the extension application.
In the extension application.
Mm-hmm. Yes.
And my apologies, madam. And in terms of that, the reason that have been advanced, they said the review application to be instituted by the applicant would involve parties which are not before the special tribunal. Preservation orders must first be obtained against them, and they will thereafter be joined in the review application involving the respondents. So that's an explanation as to why is there a need for this extension or revival. And my lady, we are told that the order of the 14th of February cannot be revived. But however, it was specifically stated in the order itself, my lady, that it can be revived. And your ladyship would find that under 14 talks about, that it can be extended, my lady. It says the applicants may approach this tribunal on supplemented papers for a variation or extension of the order above.
You're reading from what paragraph of the order?
Paragraph 14.2. The applicant may approach this tribunal on supplemented papers for variation or extension of the order. So that can be done. My lady, we are, your ladyship has been told that there are other parties that we're making reference to, and that these parties have not been disclosed. My lady, it's in the nature of these proceedings that we're having here that we shouldn't disclose that. And the reason why is because the preservation orders is intended to ensure that the properties that are a subject matter of this proceeding should not be dissipated. So if we were to disclose the names before that application is, before a preservation order is obtained, then the whole application of the preservation order will be defeated. So it is not that they are non-existing, respondents that we want to join in the review application. And I've even made the submissions to your ladyship that that application has already been instituted. On those basis, Maredi, we submitted that a case has been made out, and now that the days that are proposed in the notice of motion have been overtaken by events, we then would like to rely on that paragraph 10.2 for the revival of the order.
14.2.
10.2, 10.2, and 14.2. 10.2 of the application, extension, and 14.2 of the order. And we submit that your ladyship can exercise her discretion and grant either the extension or the revival of the order for the effective administration of justice. Unless your ladyship would like me to address your ladyship on any other thing in respect of this Rule 14, those would be our submissions, my lady.
Lady, if I may just mention one thing.
I'm sorry, give me one sec.
Thank you.
Thank you, Ms. Rostov. You want to add something?
Well,
Do you have any objections? Because now it's out of turn.
Well, it's just assistance. It's a correction with regards to the numbering my colleague is referring to in the order. Because my lady will look at the order and your notes, you will be confused because he refers to 14.2. It's actually 11.2. I just want to correct that.
Just give me a minute.
There is no 14.2.
In this, my lady, I think I was looking at a different document.
So it's 11.2 of the order.
Yes.
Yes.
Okay. Thank you, Ms. Rostov.
Thank you, Madam.
Yes. But my lady, I also wanted to add that the references in paragraph 11. That is at the order at the time. So if such supplement paper and or variation application was not brought, then obviously the argument of my colleague is moot. So nothing needs to be added.
I think I'll object to that.
Just a minute, please. Just a minute. Now we're going into arguments after arguments. So. All right, I think we must stop there. I allowed Mr. to stop because it was simply a point of correction for the convenience of the court and to, prevent any confusion. All right, I think as far as the extension application is concerned, we've dealt with it. We've actually spent an hour and a half on it. I think we'll take a short break. Can we just rejoin on the same link, Mr. Mankana? He's muted, so he can't hear. Mr. Mangana, can you hear me?
Maleda, I think the link is for 6 hours. I think that.
Okay.
Yeah, I think it's for 6 hours.
All right, let's take a short break. Sorry. Oh, you can. So we just rejoin on the same link. We're just going to take a short break now. Okay, thanks. It's 12:30, shall we say about 10 to?
That's good.
10 to 12. Thank you very much. We'll rejoin shortly. The court will adjourn.
That's the court, please.
Okay, lunch later. Nice. Die bestaan. Ja, anonim. Kan jy na my hoor? Kan jy my
Ja.
hoor?
Ja, ons kan jou. Goed en jy?
Ek sien jou die 9de in die kommersiële hof.
Jep.
Jy moet net asseblief, het goed ek jou sommer nou al sien. Ek gaan waarskynlik eers 11 uur daar kan wees. Ek het 'n aansoek om verlof tot appel wat die judge geplaas het vir 9 uur die 9de. Jy weet, en dis so ek skuis dit, maar ek is bly ek sien jou. Dat jy ek sal vir Willem ook laat weet dat ons net afstaan na 11 uur toe.
Okay, nee, geen probleem.
Sorry vir ongerief, maar ek het gister die kennisgewing gekry en sy het my ook gebel en sy sê vir my, sy sit gewoonlik in benou nie in die rondgang afdeling sit ons daar, maar sy sal die aansoek 9 uur hoor. So ag, dis ek behoort eintlik 10 uur klaar te wees. So ek sê kom ons sê maar net laat 'n afstand tot te kom, ek behoort 11 uur daar te wees.
Ja, kyk, dit lyk my lank om die beskuldigdes in any event te bring, so lyk my die gevangenes het laas hulle toe éventueel na 11 aangebring. So sal 'n issue wees nie.
Man, dankie, ek waardeer jou moeite. Ek sal net vir Willem ook laat weet, ek het daai selfde dag daai stukke vir hom gevat toe ons daar was. So ek hoop nie hy kom nou met lang stories nie.
Okay, are we all back, Mr. Mpashlele?
As the court pleases.
Are you back? Good.
Yes, I'm back, madam.
Yes, good. We've now resumed. I see it's 11:49. I said we would resume at 11:50. Right. So we move on to the next application now. That is the reconsideration application, right?
As the court pleases, my lady.
All right. Thank you, Mr. Mpashlele.
As the court pleases, my lady, like I indicated when we made submissions in respect of the extension application, there is no property. There is no property of the first, second, third respondent. That is the subject matter of the preservation. The only properties which forms part of the preservation is the property of the sixth respondent, which is Magogodela. The properties of the fourth, that is Unicas, and the fifth, that is Sibanda, and the seventh, that is Diutlileng.
Oh, I tried to pronounce that name and I couldn't. How do you say it?
Diutlileng.
Diutlileng.
Diutlileng. Diutlileng.
Krileng. Oh, the TL is Kri.
Yeah.
Krileng.
Diutlileng. It's what is it that you have heard?
Oh.
And my lady, like we have indicated that in respect of the sixth respondent, Mr. Maharaj has confirmed that the matter has been settled. There's a settlement agreement that has been prepared, wherein the seventh respondent is undertaken to pay back whatever the 388,000. This on that basis that it is now.
I didn't get that. You said the sixth or the seventh respondent is paid.
The sixth respondent, Mr. Magogodela.
Okay, because you said the seventh was going to pay, and I thought, okay, well, that doesn't sound quite right.
Yeah, the sixth is undertaken to pay that 388,000 rand that he received from the fifth respondent. From the Unicas, that is the fourth respondent. So on that basis, the matter has been settled. The understanding that it will be released from the preservation order. The only property that is now a subject of the order is the property in respect of Sibanda, Unicas, and Diutlileng. And my lady, it is not in dispute that Unicas received the 10 million rands from the National Lotteries Commission, NLC, which was intended for the construction of athletic tracks in Galishio. It is not in dispute. In actual fact, even the fourth and the fifth respondent, that is Unicas and the Sibanda, are conceding to that particular fact. That is also, or this submission is also supported by the first and the second respondents. If I may refer your ladyship to the answering affidavit of Ms. Khoza, that is the second respondent, answering affidavit.
Of the cause of Audrey Khoza.
Yes.
Yeah, because we've got two Khoza, so you're looking at Audrey Khoza.
That is Audrey
Yes.
with Khoza. My lady will see that from paragraph 6, she speaks about what transpired between her and Sibanda. She's saying on paragraph 6, on or about 9 February 2018, I received a call from an unknown man whom introduced himself to be Ms. Jabu Sindani, hereafter called Sibanda, and that he is the provincial manager of the National Lotteries Commission, herein referred to as NLC in Mpumalanga. 7, it says Sibanda informed me that the Chief Executive Officer of the NLC, Charlotte Mampani, year in after called Mampani, and the Chief Operations Officer of NLC, Philemon Ledwaba, year in after referred to as Ledwaba, and the chairperson had sent him to approach me to assist to build athletic tracks in Northwest, Mpumalanga, and Northern Cape provinces.
Yes.
Then on paragraph 8, it says, on 11/2018, I met Sibanda at Clearwater Mall. During the meeting, Sibanda informed me that an application for funding on behalf of the first respondent was already lodged by the NLC. That in itself means that after all, it was not the first and the second respondent that submitted that application to the NLC. Then we have 9. Sibanda indicated to me that he required the assistance of the first respondent, that is Inqaba Yokulinda, in order to see through the success of the building of the athletic tracks. The first respondent was a credible NPO that had received funding over 20 million in the past financial years. Then, on paragraph 11, it says, the first respondent was accordingly awarded a grant to the value of 15 million, that is project number 109204, from the NLC, signed by Ledwaba. Ledwaba is one of the people that have sent Sibanda. Then it said the contract agreement was signed on the 26th February 2018 to construct athletic tracks in the Northern Cape.
Well, I think it's not necessary to read all the paragraphs. I've read it's just to highlight the points you want to make in respect of it.
So, my lady, on paragraph 14, your ladyship will see that after all, Magogotela instructed, that is the sixth respondent that is now settled, instructed the first respondent to transfer 10 million rands into Unica's account. And then from there, my lady, he went on to say that the first respondent, on 16, the first respondent, Sibanda and Margot, signed an MOU in order to have the document to effect Sibanda that Sibanda received 10 million rand and indicated the respective parties' responsibility. Then the important point is this one. To date, Sibanda has not sent the project plan, detailed invoices, or progress reports relating to the building of the athletic tracks and the use of the 10 million rand.
That's which paragraph?
Paragraph 17.
Oh, 17. Okay.
Yes. So we have a 10 million rand, my lady, that went to a 10 million rand that went to Unicas. That is not denied. That is not denied by Sibanda or the fourth and the fifth respondent. That is not denied. In fact, if your ladyship could have a look at their answering affidavit.
Yeah.
That is paragraph 102. A very interesting respondent 102 said, I deny that Ms. Khoza transferred the funds on my instructions. On the contrary, Ms. Khoza transferred the 10 million on her own accord as an NPO was contractually obliged to do. That's what he said. Over and above that.
Just a minute. Yes.
Now, my lady, it is now common cause that a 10 million rand from the NLC, which was intended to build the tracks, athletic tracks, was transferred into the account of Unicas. And my lady, that transfer My lady, I don't. There's a bank statement to that effect that is attached. That is in terms of our own case land numbering is at 020. There's a bank statement to that effect. So that is not in dispute, my lady. All right. That there's a 10 million rand which has been transferred into the account of Unicas. And at the time of the transfer, my lady, the account of Unicas as of 7 March 2018, the balance thereof was about 1,925. That was the balance on the 7th of March 2018. And your ladyship will find that in our heads of argument, paragraph 5.2.4.1.
5.4.2.1.
5.2.4.1.
2. Okay.
And then on 5.2.4.2, we then said on 12 March, there was an amount of 10 million deposited into the account of Unicas. Then on 13 March, from the 10 million, 360,000 was deposited and transferred into the bond registration account for the attorneys of the 6th respondent. The 6th respondent, that's Magogodela, whom we've settled. That's the amount that was transferred there. And then on 27, we have 205 into the account of the auto integrity repairs. And then we have all these amounts. And this is not denied, my lady. It's not denied. If your ladyship would have a look at paragraph 121 to 126 and 127 to 129 of the answering affidavit. So it is quite clear from these transactions, my lady, that these transactions came out of the 10 million rand that was paid into the account of Unicas. Now, my lady, that then becomes the reason why all these properties, which are the subject matter or are contained in Annexure A, have been a subject of a preservation order. Now, my lady, the application has been instituted in terms of Rule 24. And Rule 24 provides the following, my lady. In terms of Rule 24, 2, it said the application must demonstrate that the property concerned constitute the proceeds of an unlawful activities emanating from the findings of an investigation conducted by SIU, pursuant to a proclamation made by the President relevant to the investigation in terms of Section 2. We said there is a proclamation that was in November 2020, my lady. We are saying that is all this is pursuant to an investigation by the SIU, and that these properties are a subject of unlawful activities. Unlawful activities in that the 10 million was intended to build tracks, but however, the funds ended up being utilized for the properties that are on Annexure A. And for that, my lady, we submitted that after all, the applicant has satisfied the requirements of Section 24, and that the application for the reconsideration should then be dismissed with cost, my lady.
That's in respect of all the applicants who have applied for the reconsideration.
That is correct, my lady. My lady, what the respondent are actually trying to submit, despite them not presenting any form of a defense, they are saying the properties that are a subject of preservation order have not been procured by the funds from the LLC. We are saying that is not what Section 20, Rule 24 requires. It doesn't make mention of the word procure. It makes a reference to the fact that the properties must constitute the proceeds of an unlawful activity emanating from a finding of an investigation conducted by an SIU. So the word procure is a word that has been coined by the respondent that has been imported into Rule 24. And therefore, that is not a defense to this particular application. Unless your ladyship would want me to address your ladyship, those will be our submissions.
Thank you.
As the court pleases.
Thank you. All right. I think, are we going to maintain the order in which you argue, or are you happy for Mr. Pistorius to argue, Ms. Rostov?
My lady, it's up to Mr. Pistorius. I have no objection if he wants to go first, but it doesn't matter.
Mr. Pistorius?
Lady, I respectfully submit that for proper housekeeping, you've already ordered that Ms. Rustov being representing respondents before myself, so I don't have any difficulty if she proceeds.
Thank you. All right, Ms. Rustov, I think if you can kick off.
Thank you, my lady. My lady, my learned friend for the applicant indicates that there's no property of respondent 1, 2, or 3 that's the subject matter of Annex A. However, my lady, we need to have regards to the court order, which was sought by the applicant and granted then, especially if my lady will have regards to 2.2 of that order.
Just give me a minute. Yes, thank you.
Now, in terms of paragraph 2.2 of the order, it reads that the 1st to 7th respondent are directed to disclose the whereabouts of the preserved assets, that's the assets in Annex A, and any other realizable assets of the 1st to 7th respondent acquired with the funds received from any of the cited respondents. So it doesn't just include the assets of Annex A or the property thereof, but also any other realizable assets in respect of the 1st to the 7th respondent. Then further, my lady, paragraph...
Just a minute, just a minute.
Yes, my lady. Then, my lady, if such disclosable assets are then found, paragraph 4.3 of the court order then directs no one except the curator bonus may deal with the preserved and disclosable assets subject to the conditions and exceptions contained in this order, save with the prior written consent of the applicant, which consents may not be unreasonably withheld. Further, 5.1 with regards to motor vehicles. Again,
just a minute.
Yes, my lady. At 5.1, it's within 7 days of the granting of this order, all motor vehicles belonging to the 1st to 7th respondents, which are preserved and or disclosable assets, must be delivered to the curator bonus. Again, it's not just Annex A's assets, but all other disclosable assets. Then further, my lady, at paragraph 8 of the court order, which deals with the cost of the curator bonus, it indicates 8.1, the cost of the curator bonus occasioned by and incurred in the implementation of this order are to be paid by the 1st to 7th respondents jointly and severally. Again, it includes the 1st, 2nd, and 3rd respondent, well, all respondents. first to the seventh respondent, jointly and separately. So, my lady, this order is not just in respect of Annexure A's assets. This order is much wider. It specifically includes the first, second, and third respondent with regards to disclosable assets. It further provides for the first, second, and third respondents to pay the cost of the curator bonus jointly and severally. So surely the argument by the applicant that they're excluded from Annexure A, so why do they want the court order to be reconsidered, is not a valid argument, because they specifically made or requested the order to be wide enough to include other assets, if it is so found, as well as costs orders against the first, second, and third respondent. So on that basis, that's then also one of the reasons why the respondents are opposing this or bringing this reconsideration application. My lady, further, with regards to my heads of argument, I also indicated to the Honourable Court that one of the reasons is that the applicant was not true in bringing this application ex parte, in that they did not disclose all material facts to the court of first instance to have considered this application ex parte. They are obliged to have provided the Honourable Court or the Honourable Tribunal with all the information at the stage when this application was brought. For instance, my lady, we now know that the applicant based their application solely on what the second respondent has informed them. And why is that? Because it's the second respondent, which they did not disclose to the court. The second respondent is the one who approached them, who approached the Hawks, who approached the SIU, who opened cases, criminal cases in this matter. It is the second respondent who actually approached the NLC to inform them of the 10 million which was paid to the fourth respondent, and that the fourth respondent is not performing what was required in building the tracks. It is based on this information. Because the second respondent and the first respondent didn't merely sit and do nothing about this. From the first and second respondent's affidavit, my lady, answering affidavit, it's evident that they had a consultation with the SIU. It's evident that they have informed SIU as well as the NLC about all these facts, about all the correspondence, about all the emails, as to what happened to the 10 million. Because clearly from the applicant's argument today, this preservation order is merely based on the 10 million, because she refers to what happened to the 10 million, and that is the asset that was bought specifically from the proceeds of the 10 million. Now, the first and second applicant already provided them a full, detailed description of exactly what happened to it. So why are they included in this application, first of all? Second of all, why did they not inform the tribunal that this is the case? This is what the second and the second respondent has informed us. My lady, what is also strange is,
just a minute.
The applicant decided when they brought this application, they're not even going to tell the court or inform the court that the project was completed. That they themselves, in February 2021, a year before they brought this application, went to the site and saw that the electric track was in fact constructed by the first and second respondent, for which the money was provided by the NLC. The money that was lost, the 10 million, a full explanation was provided. Again, that wasn't given to the court to make a decision when granting the order on the 14th of February. But in fact, my lady, what the applicant tried to do in the application is they tried to create an impression to the court to say that there was collusion between the respondents. Whereas the first and second respondent clearly, in the interview with the applicant, already set out that there was no collusion, how she was involved with the fourth and fifth respondent, what transpired, when the money was transferred, what was the reasons for such, what she did thereafter to recoup that money, that the NLC actually informed her that they will get the money back. Mm-hmm. What they also have not informed the court is that actually the applicants had a meeting with Mr. Sibanda, the fifth respondent, in which they wanted him to sign an acknowledgement of debt based on the information provided by the second respondent. All of this information they neglected to inform the court of. Recklessly, if I might add, because that is information the Honourable Tribunal should have been provided before considering granting an order against the first and second respondent. Mm-hmm. Further, my lady, the respondents that the first and the second respondent made full disclosures to the authorities, that's to the Hawks, to the police, to the applicants, as to what transpired. And they are the ones who should have been protected. Yet, due to the non-disclosure by the applicants to the Honourable Tribunal, that was not the case. They were thrown in, included in this court order. The Prevention and Combating of Corrupt Activities Act specifically required the respondents to have acted in accordance with the Act, which they have done. They made the disclosures. And was it not for the first and second respondents, the applicant would not even known about this matter. But the second respondent is the one who, after she reported and nobody wanted to listen to her, she went to the media. Attached to her affidavit, my lady, is the clippings of the media wherein she reported to them. And only then did the applicant decide to have an interview with the respondent. They took all the information from the respondent, the second respondent, and then again included her still in this order. Mm-hmm. Well, it is my submission that the applicant then willfully failed to mention all of these information to the tribunal at the stage when they made the application. And had they informed the court this order would not have been granted against the first and second respondent, because there's clearly no evidence whatsoever that the first and second respondent colluded with any of the other respondents. As a result, my lady, the application or the order should not be confirmed, and it should be dismissed with a cost order.
Are you talking about only against them now, or the entire application, or the entire order?
Yes, the entire order with regards to the respondents 1 and 2.
Thank you.
My lady, with regards to the third respondent, I did separate heads of argument because they all filed separate affidavits. With regards to him, the argument is more or less the same, my lady, that except for being mentioned during the headings of who's the parties, and he's described as the treasury of the first respondent, nothing else was ever stated by the applicant against the third respondent. Yet they sought an order against the third respondent as well, which will include exactly the same paragraphs I've already mentioned in the court order. So the only evidence is then he's the treasurer, and because of that he needs to pay now the cost order of the curator bonus. He needs to be investigated for any disclosable assets, but there's nothing against him, no involvement, no collusion, no evidence. If we have regard specifically to Rule 24(2), my lady, that the application must demonstrate that the property concerned constitute the proceeds of unlawful activities emanating from the finding of the investigations conducted. There's no evidence of any investigation against the third respondent. There's no evidence of any property which the third respondent obtained or which emanates from unlawful activities. There's no evidence whatsoever against the third respondent, and there's no reason whatsoever that he should have been included in this order. And on that basis, for him as well, the third respondent will ask exactly the same, that the court order should not be confirmed in respect of the third respondent, that he should be released from this order, and that the applicant should pay the cost. My lady, then with regards to the 12 and 13, Ms. Gloria Causa, nowhere does it indicate, because it only refers to the first to the seventh respondent, but yet they are included in the court order. So Gloria Causa is included for no apparent reason. Why should her name be on the order if there's no relevance to her? So on that basis, she should be removed from the order. It should then only be relevant to the ones as indicated by the friend with regard to this. Because if there's no property, there's no involvement, there's no even investigation against her, why should she be included in this order? Therefore, again, the same relief will be sought that the court order should not be confirmed in respect of the 12th or the 13th respondent, and that she should be released from the order and the applicants to pay the costs of the application. My lady, then there was, I know my lady indicated this morning you do not have the condemnation application in respect of my heads of argument. I'm not sure if the court would want me also to argue on this respect, or...
Let me just ask Mr. Mpashlele and Mr. Pistorius if there's any objection to that or opposition to the condonation application. I don't know what the full extent of the explanation is. I just got snippets of it from the heads, and hence I realized that it was due to the short time and the unavailability of the legal representative and so on. But let me hear what Mr. Mpashlele has to say.
Yes, court, please.
You're muted, Mr. Mpashlele. I can't hear you.
Thanks, my lady. My lady, we haven't filed papers in respect of the condonation application itself. But the submission that we could make is that condonation is at the discretion of the court, and therefore it's for the court to decide as to whether it wants to grant condonation on. But we haven't filed any papers, so I have no instructions as whether to oppose or not to oppose.
Well, I'm sure that the tribunal, Mr. Mfunana, will send me the relevant affidavits. And I don't think there's a major problem with me actually considering the condonation application on, because I got the sense that there was no opposition to it in respect of any of Ms. Rustov's clients.
Indeed, so, my lady. There's no opposition filed.
Mr. Pistorius, you confirm that?
We don't have any objection to the application for condonation. Thank you, my lady.
My lady, then with regards to condonation, I will then stand by my submissions made in my heads of argument in that regard, lady. Lady, that will then be my argument unless my lady wants...
That's fine. Thank you, Ms. Rustov. I just want to note the issue about the condonation.
Thank you, my lady.
Thank you, Ms. Rustov. Mr. Pistorius?
I'm a deputy to the court, my lady. As an opening submission, it is our contention that the main question to be decided on the main application is whether the applicant has disposed of his evidentiary owners to prove that the property concerns constitute the proceeds of unlawful activities. We respectfully submit that the applicant has to demonstrate that the property concerned constitute the proceeds of unlawful activities, and we submit on behalf of all my clients that I represent that the SIU failed to demonstrate same, and accordingly that the application should be dismissed with cost. Before I deal with the main contentions on the merits of the application, I refer your ladyship to Rule 10.4 of the Tribunal rules, which makes specific provision for reconsideration of an order on aspects of law, and with that the respondents 4, 5, and 7 dealt extensively in their answering papers, which you will find on 10.11, where it's...
Sorry, you say we found where?
10.10, and going over to 10.11, where we, as we state in paragraph 27 and further on, we rely on points of law, which I will allude to as briefly as I can.
Sorry, the 10.10, sorry, Mr. Pistorius, the 10.10 and 10.11 is of the papers or your heads?
Yeah, and you will find it on paragraph 27 of the answering affidavit of the respondents. That is where we deal with the order granted and reconsideration of the order on points of law.
Mm-hmm.
Goes on to 10.11, lack of urgency and the like, which I will briefly touch upon.
Just give me one moment. I just want to turn to the answering affidavit so I can follow what you are saying. Yes. All right. I'm at paragraph
27. And we say in paragraph 27 that in terms of Rule 10.4, the respondent is entitled to raise points of law, and we then proceed to do so in the subsequent papers and paragraphs that follow. First of all, in my heads of argument, I dealt in limine again with the lapsing of the order, which obviously falls part and parcel of our submissions in limine regarding lapsing of the order, which I will not repeat. So as a result, I respectfully will stand with that submissions because it forms part of the main or the first application. My lady, if I can deal then with the issue of lack of urgency, again, the nature of the proceedings which the applicant opted to follow on an ex parte basis, urgent application, the argument is not addressed in his submissions to yourself, but this court is adjudicating this application as if the respondent were not before the court for any relief that was sought in his absence. So the issue of urgency is not moot, and one has to deal with the aspect whether the SIU had any just cause to move an urgent application. We say with respect that the application in itself did not show at all why there were urgent considerations to move this application on an ex parte basis. Neither were there any failure or were there a failure to make out the case why the application itself was urgent. You will find that I have addressed those issues also in my heads of argument. If I may then proceed to the main concerns regarding the assets, regarding the 4th, 5th, and 7th respondent, which I will deal with simultaneously, it pertains to a Honda Jazz vehicle, a Mercedes-Benz AMG E63, and a Mercedes AMG 63, as well as an Audi with a registration number BYFHGP. Your ladyship will find that being comprehensively dealt with in the answering affidavits, but with quick reference, I refer you to page 10 from paragraph 8 of my heads of argument, where I make short submissions in this regard. The importance
did you say page 10? Sorry, Mr. Pistorius.
Page 10. I'm sorry, I know that updated with papers. Page 10, paragraph 8 of my heads of argument.
Thank you.
My lady, my respected opponent claims that the respondents has not made out any defense and did not put out any defense in their answering papers, which is obviously, our submission is quite wrong. The respective respondents dealt extensively with the vehicles concerned, and with reference to the word procured, it is our submission that that is purely semantics. It could have been, the word procured was my choice to use, and it was not intention to be not within the ambit of the relief sought. It could have been obtained. So the word procured should not be read out of context. We say that the particular vehicles is explained in detail under oath, not only by the 4th and 5th respondent, but also by the 7th respondent. If I can in short deal with the Honda Jazz vehicle, the 4th respondent attached to his answering affidavit a confirmatory affidavit of Mrs. Koza, who clearly proves that the vehicle, I beg your pardon, the Honda Jazz vehicle was a gift from his aunt Maria Sibanda, which she attached to a confirmatory affidavit together with the registration papers of the said vehicle. Likewise, that Ms. Maria Sibanda confirmed that that vehicle was purchased under a fund from Netbank, which he attached as Annexure 5 RAF4, as well as then the letters from Honda South Africa to Ms. Maria Sibanda that this vehicle was paid off, and that a registration document dated 13 November 2018 was in her name. So the allegation by the SIU that this particular, as a result of unlawful activities or proceeds of crime, that is patently false. It is then clear that this vehicle ought to be released at the Vinci on preservation. If I may then deal with the Mercedes-Benz AMG, the deponent, the fourth respondent, clearly states that this vehicle was purchased during 2018 at Bullseye Auto.
Well, I'm not sure. Sorry, Mr. Pistorius, I'm sorry to interrupt. Wasn't the allegation that the cost of the repairs for those vehicles was actually... So, okay, can you hear me now? Can you hear me, Mr. Pistorius?
I hear you now, thank you.
Yeah. I think that the allegation...
I hear you, thank you.
Yeah, it's not the acquisition of the vehicle or the ownership or how they acquired the vehicle. It's the cost of the repairs to both vehicles, which was paid out of that 10 million. That, as I understand to be the submissions of the SIU. That I can't remember the amount, 300 and some odd thousand maybe. That was paid to the garage that fixed those vehicles. That is the reason why they attached or they placed under preservation the two Mercedes vehicles. Similarly with the Audi, it was paid for out of or after they received the 10 million rand transfer into their account. So I think that was the allegation, not that, you know, they're saying that you used that money to buy those vehicles. It's to repair those vehicles.
What the response says that allegation is factually wrong, and attached to the papers, the answering papers, proof to substantiate the factual allegations upon which the submissions are made. That is why, and I'm not going to take you through all the papers because we are time constrained, but I maintain on the answering papers and attached annexures. Clearly the respondents has disclosed a defense, putting affidavits and or documents proving where, when and how these vehicles were obtained. Because in contention, what the applicant must prove and demonstrate is that the property concerned constitute proceeds of unlawful activities. That is the crisp issue to be decided by yourself. And as a result, what the respondents did is they manifestly proved this contentions to be incorrect with supporting papers. So as a result, we respectfully submit that the applicant yet again failed to make out a case, and particularly if you have regard to the replying affidavit as well of the applicant. We make the point on page 10 yet again of my heads of argument that in the replying papers, the applicant opted not to deal whatsoever with the allegations of the respondent, that's the fourth respondent, regarding the Honda Jazz vehicle as well as the Mercedes-Benz. As a result, it should be without any doubt a failure by the applicant to prove that these particular vehicles were the proceeds of crime. Similarly, we respectfully submit that the applicant's foundation regarding Mercedes-Benz vehicle, he proved with annexures that that vehicle was already, he became the registered owner of that vehicle in August 2016, way before the alleged grant of the award to the first and second respondent. So yet again, the allegation that the Mercedes-Benz vehicles were acquired or
sorry, Mr. Pistorius, you're breaking up. Sorry, I can't hear you. Mr. Pistorius? I'm sorry, you
As
broke
we
up
submit
there.
that. Sorry, can you hear me now?
I can hear you now. I just didn't catch the
you hear
last
me?
bit of what you said. I just didn't. I got to the point where you said he became the owner of the Mercedes-Benz long before this.
Steffi, can you hear me now?
I can hear you now, yes.
Hello?
Yes, I can hear you, Mr. Pistorius. Your picture is frozen, but I
can you hear me now?
I can hear you.
Sorry, I can't hear you well. It seems like I have a break in my transmission or the network.
Yes.
It says bad network quality. I do not know. Can you hear me?
I can hear you now, but the last bit. Yeah.
All right.
Now you're breaking up. I can't hear you.
Let me repeat it, my lady. Can you hear me now?
I can hear you.
We say with regard to the Mercedes-Benz, the respondent, the fourth respondent proved that this vehicle was acquired already in August 2016. And as a result, the allegation that these vehicles were all acquired after the grant was made and paid into the account of the fourth and fifth respondent, it's factually simply incorrect. As a result, we also say in our answering papers, and we submit that in our argument, that the applicant simply failed to disclose material and relevant information pertaining to the relief it sought, especially when they come on an ex parte basis, which in itself is to be severely criticized. They did simply not play open cards, my lady. We submit they relied, for instance, on an e-notice report consisting of page. In any event, the e-notice report, the one page consists of hearsay evidence, but upon perusal of the complete document, the obvious explanation by the respondent would have been self-evident. My lady, then the respondents also deal particularly with the loan agreement, which was dealt with in his answering papers, and as a result, we submit in finality that the applicant
Sorry, Mr.
relies heavily on hearsay evidence on papers. Yes, we submit that the applicant heavily relies on hearsay evidence in his founding papers, contrary to the rules of evidence, which is specifically made provision for in the rules of this Honourable Tribunal. If I may refer you then to Rule 9, specifically Rule 9.2, which deals with, and I may maybe read that into the record, that the rules of evidence applicable to proceedings shall apply to the proceedings before the Tribunal, save where the Tribunal directs otherwise. As a result, my lady, we say that the applicant's founding papers relied on inadmissible hearsay evidence, documents such as the notice report, which consists of hearsay evidence and the like, and only did they rely on one, as it's deposed to by the applicant in his founding paper, meeting or consultation with Ms. Koza. The applicant does not whatsoever factually support with confirmatory affidavits the correctness of that submissions made by the deponent Nkubeni in his founding papers, and as a result, we submit that the applicant's applications fall far short solely on evidential basis as well. My lady, we respectfully then in finality submit that the applicant, in its failure to disclose material information and information specifically which is devastating to applicant's main application, particularly in export, that this application in its entirety should be dismissed with cost. That is submissions on behalf of the fourth and fifth respondent. As far as the seventh respondent is concerned,
Sorry, just a minute.
The brief
Sorry,
is
just a minute.
I'm sorry.
Sorry, you were saying with regard to the 7th respondent?
She relies on the answering affidavit of the 4th respondent, stating that the vehicle was a gift and that she has no knowledge, nor did she become party for proceedings, and as a result, that aspect were not dealt with in any reply by the applicants, and that application itself against the 7th respondent ought to be dismissed. As a result, my lady, I would then later, when I deal with the rescission application, will deal more specifically with procedural shortcomings of the application itself. But on the main argument, I respectfully submit that the applicant simply failed out the towing vehicle in the application. That is my submissions. I will rest with the remainder arguments as formulated in my heads of argument.
Mm-hmm. Thank you, Mr. Pistorius. Reply, Mr. Mphahlele.
As the court pleases, my lady. My lady, an interesting point that I want to bring to the attention of the court is that this is a reconsideration application. What that's supposed to mean is that the order of the 14th of February 2020 is a subject of the current application, which means that in the event that the honorable court confirms that order, it means that after all, the order stays. If it dismisses it, then it means that the preservation order is of no force and effect. But I would like firstly, my lady, to firstly deal with, if your ladyship would allow me, to deal with the submissions by my learned colleague, Mr. Pistorius. Now, my lady, Mr. Pistorius concentrated on the amount that has been spent in respect of the motor vehicles. And from the argument or the submissions that made by Mr. Pistorius, that loses sight of the fact that the preservation order is intended to make sure that after all, the realizable assets are not dissipated. But now, my lady, we have 10 million rands that has went into the account of Unicas. That is admitted by Unicas. That's the first and the fourth and the fifth. They admit that, my lady. But however, my lady, all that they're saying is that no, but this amount was not used to acquire. That's not the purpose of the preservation order, my lady. Hence the case that we are referring to in our papers. My lady, not only was all the amounts that we are referring to, including the 2.5 million that we refer to, and my lady, I just want to refer your ladyship to the fourth and fifth respondents answering affidavit.
Just a minute, just hold on. Yes, what paragraph?
Paragraph 127.
Okay, I'm there. Yes.
127, my lady, is an admission that relates to paragraph 16.1 to 16.5. Which admits that on the 30th of March there was a transfer of 58,000 and so 635,000 to Hota. There's 2.2 million to Clippers Financial Services.
What paragraph again from the founding affidavit?
Paragraph 16, my lady, of the founding affidavit.
Yes.
And my lady, we're referring to a company that had about 1.9 thousand in accounts, and it gets the 10 million rand intended to construct athletic tracks. And after getting that money, it takes about 58,500. It pay being human detox center, that is 16.1. 16.2, it takes 635,000. It transferred that to Khotla Kukama, wherein we indicate that further investigation is ongoing. Then 16.3, it takes 2,207,000. It transferred that into Clippers Financial Services to service a loan. And then from there, an amount of 182,000 in 16.4 was transferred to the account of Unicas for personal account of Mr. Sibanda. Then we have a 2.1 million that was transferred to the Unicas Standard Bank on March 30. And all this admitted, paragraph 16.1 to 16.5, I admit the contents of this paragraph. Now, my lady, even when you go to 16.7, we talks about the 2.5 million that, my lady, we've indicated to your ladyship that is a subject matter of a preservation order that has already been filed. They say, I admit the payments of this amount, but I have no knowledge of the remainder of the contents. I deny the knowledge of ill-gotten funds or unlawful conduct. I know that the matter has been investigated. So our submission is that this falls squarely within the ambit of Rule 24. Now, Malena Korik then says that he has used the word procure incorrectly, and now is using the word acquire. That's not what we are saying. We're saying that after all, this constitutes a proceeds of an unlawful activity. That's what the applicants are saying. They were not saying they've been acquired by this thing or they've been procured. We're saying they constitute a proceeds, and that falls within and these properties. For instance, repairs have been made from the funds of the NLC, which funds were not meant for those repairs on those cars. An amount of about 200 and something thousand was paid for the procurement of the Audi of the Utluleng, and that is the money that comes from the 10 million rand of the NLC. That constitutes a proceeds of an unlawful activity.
Paragraph 126 here.
And my lady, even on the answering affidavit, paragraph 121 to 126, they admit all those payments to the CAS. Talk about, they make reference that we admit that 60,000 was paid to covered motor vehicles for repairs. We admit that 50,000 was paid to Para, the applicant. And then from there, they then say 50,000 was a deposit for the purchase of a motor vehicle from the dealership. So all these things, they are admitted. So on that basis, we submit that the applicant has made up a case for the confirmation of the order that is obtained on the 14th of February 2022. Now, my lady, on the issue of hearsay.
Just a minute.
My lady, firstly, my submission on that point is that allegations in relation to what has transpired, what Mr. Mokeni was informed by Ms. Audrey Khoza. Ms. Audrey Khoza has confirmed that in her own answering affidavit. So they know they are not hearsay. In actual fact, that's what Ms. Audrey Khoza has informed the investigator, and that has also been confirmed. Even though it's not a confirmatory affidavit, but if one looks at the affidavit of Khoza, she confirms that. She confirms firstly that there was no application that was made by Inqaba Yokulinda. No application was made by them. That application was the one that was prepared by Magogotela with the knowledge of people in the NLC. She confirms that. She confirms the fact that after all, that she has never dealt with the issues of construction of athletic tracks. Her own, the MPO's main objective was to deal with youth having drug problems. It was never to build. And I'll come back on the issue that has been advanced by Ms. Russo in relation to the fact that tracks have been built and whatever. From the 10 million rand, my lady, there's no athletic tracks which were ever constructed with that. It's very clear from all the papers, to a point wherein the first and the second respondent in their own answering affidavit on paragraph 19, they're saying, to this date, Sibande has not paid back the 10 million rand. The leadership will find in paragraph 19. It reads as follows. On 27 July 2018, I cancelled the contract with Unicas and Sibanda and requested him to repay back the 10 million. Today, Sibanda and Unicas have not paid back the 10 million rand, except he signed an acknowledgement of debt in 2019. So the 10 million rand has never been utilized for the purpose of which it was intended. So I find it very strange to say why is Unicas and Sibanda defending this matter. I find it very, very strange because they cannot come and say they've done work that was meant in terms of the funding that was provided by the NLC. They can't say that. Now, on the issue of the hearsay, my lady.
Just hold on a minute.
Let the court please.
Yes, thank you. On the question of hearsay.
Yes, my lady. Not only are the allegations made supported by Audrey Khoza. However, I've made reference to your ladyship to Rule 28.2. And the last part thereof, which says that, 28.2 said the tribunal may, the exercise and in the performance of its functions or in any incidental matter, take any steps in relation to the hearing of the matter before it, which may lead to the expeditious and cost-saving disposal of the matter, including abandonment of the application of any rule of evidence in order to achieve the objects of the Act. So the strict compliance of rules of evidence that has been sought by Mr. Pistorius can easily be abandoned by the court if that would assist this tribunal to achieve the objects of the Act. My lady, that would be my submissions on the hearsay. The other submissions are in my heads of argument. On the rescission application, my lady.
Just hold on, we haven't gotten there yet.
Okay.
I think, just give me 1 minute, but straight after this, it might be more convenient to deal with the striking out application and leave the rescission for the end. But I see it's 1 o'clock. I don't know if you want to conveniently deal with both applications after the lunch break, or do you want to go into it now? Because then we'll probably settle about 1:30, or maybe even more. Well, that application only involves Mr. Pistorius's clients and the SIU. Then it won't involve Ms. Rostov.
Allegation that she built the stadiums.
I'm in your hands. Would you like to
do with them after the lunch break, Malidi?
do both of them after the Mr. Pistorius? Are you happy with that?
I'm happy. Thank you, my lady.
Are you happy with that, for us to deal with the other two applications after the lunch break?
Yes, my lady. Thank you.
Okay, good.
Can you
So
hear me?
we'll
Yes.
adjourn until 2:00 then. We'll resume at 2:00.
As the court pleases.
Thank you.
Thank you, my Yes. So, leave. Hello, Si.
Hi, Pete.
How are you?
I'm all right, and how are you?
Fine. Let's be quick. It's difficult with this virtual hearing, eh?
I beg your pardon?
I say it's difficult with the virtual hearing. One can't hear the judge sometimes, or let's hope it goes better now.
Yeah, there was some time, I think after you have changed the computers, you are much better now.
Is that so? I think, yeah, because I've got an old computer, I think I must maybe get myself a new one, because I'm using now the tennis one is a bit better.
Yeah, no, you see, you are breaking now. You're breaking again.
Yeah, I think it's your Wi-Fi that's the issue.
But me and my Si is in the same building. He's just sitting on a higher level.
Oh, okay. Then it's on. Then I don't know.
Are you using a laptop or a desktop? Is it a
laptop? Yeah.
I'm using a desktop, and because a desktop now is connected not by Wi-Fi.
So it's your own. Yeah, and I think that's much better than
Yes, and that's one of the reasons why I most of the time come here, because now I know that I'm not going to use a Wi-Fi. Wi-Fi times it's unstable.
I think it's ET. You sent ET to come and sabotage my laptop.
It's laughing.
Boy. No, we're going to be quick with this next. The decision and the striking out is going to be quickly.
Yeah.
But I missed you at the function last night.
I beg your pardon?
You were not at the function last night.
And I was under a lot of pressure. Remember, that matter of the national commissioner that I had to deal with. There was another application, so I was hectic. I had no time this week.
I also just spent an hour there. I saw you too.
Oh.
I
wish I was him.
I was saying to him, why are you not preparing? Why are you here? But you're seeing that your leader is working. I was quickly push with this. Is the judge back?
Not yet.
Who's your Wi-Fi by jou? Is it
Ja nee, hier's nie issues enigstens nie. Ons gebou Wi-Fi is gelukkig nie naby aan my, so hy's redelik sterk. So no issues.
My Wi-Fi on my kantoor is nie altyd so wonderlik nie.
That's what Lady Kitten is.
Right, good afternoon. Okay. Dana is, I see he's there, he's just muted. Just want to know if he's present. You're present, Mr. Mkana? Ah, good. All right, don't forget to send those documents to my secretary. You have her email address. The condemnation application in respect of the first, second, third, and 13th respondents, and the affidavit to the replying affidavit. I just want to see which replying affidavit again. Yeah, I think it's the, if I'm not mistaken, it might be the replying affidavit to the Rule 14 application, because he said that Mr. Nchwe is the one who examined those bank accounts of the fourth respondent and came up with those figures. So it's that confirmatory affidavit of Arlington and Nchwe, please, if you could have that sent to her. Thank you. Sorry? Yes, please, because I will need that. And she's also trying to get hold of you to speak about next week's matter. I don't think she has your email address. Perhaps it'll be on your system if you could just send her an email so she has a record. She just needs to chat to you about next week's matter. Thank you. Right, we resume now the hearing. Before we move on, something popped into my head, Ms. Rustov, which perhaps I ought to, if I thought about it earlier, I would have asked you. With regard to the second respondent, and I mean, it is quite clear from the papers that she's been, once she realized she had a problem with the fifth respondent, she went to extreme lengths, really, to try and get people's attention to what the situation was. My question is this: right at the beginning, she says she did not apply for this funding, nor did she complete all the documents, and so on. It was brought to her attention by the fifth respondent that this was the position. And it actually arises from what Mr. Mpashlele had said, that they didn't have a footprint in the construction industry. That is the first respondent, and specifically not a presence in the construction of stadia or athletics tracks and that. I'm interested to know why she agreed to get into this arrangement. Nobody's dealt with it.
Yes, well, in her affidavit, she did indicate that, and even in the applicant's affidavit, is that the Athletics South Africa issued a letter to say that they do know the fourth and fifth respondent, and that they are, because she was told that they are the ones who will be able to fulfill that requirement of constructing the track. Yes, because they on paragraph 7 of her answering affidavit, my lady, it is Simbanda. So it's the fifth respondent informed me that the chief executive officer of NLC and the chief operating officer of NLC and the chairperson had sent him to approach her to assist the build of athletic tracks for the northwest, the Mpumalanga and the Northern Cape. So at that stage, she believed then that the tracks would be built. She'll get the funds, and then some of the funds will go specifically to the fifth and fourth respondent to build the tracks. And then the other funds is then for the development of the youth to use this tracks, because it was for the youth. And that's where her organization is very strong at, is with regards to the development of the youth. And the tracks was part of that development. And because she was then told that there are people, the fifth and the fourth respondent, who has done it before and will be in a position to assist her, and they have already applied and they've done all the necessary quotations and documents for the NLC to be granted this, and that's why she
She only came to this knowledge and she caught sight of this letter of recommendation or endorsement from ASA subsequent to the fifth respondent, Mr. Sibanda, contacting her. Yes. And he was unknown to her.
Yes.
And, so I'm a little, it's a bit nebulous that, this whole relationship and her reaction as, to him to say, but I'm not in the construction industry. And I mean, she says that he wanted her to do them a favor. So she went into this knowing that she herself is not going to be doing the construction. That's what I want to know.
Yes, it was when she was approached from that point already, it was indicated that the fourth and fifth respondent will be the ones performing the construction of the track specifically. But obviously the other work around the track, because it's the track, but it's also the painting, and I think there were some pipes and that type of thing that was done by her side. But the track itself was supposed to have been built then by the fourth respondent. And that's why she agreed, because she was then informed that they do have the required knowledge. They have done it before.
So this was initially communicated to her by the fifth respondent.
Yes, Mr. Sibanda, yes. as well as the sixth respondent, because when she met the sixth respondent, he also confirmed that is at paragraph 12, that he had submitted the application and advised that she will be working with Sibanda, the fifth respondent, whom I had known and introduced to me as Mr. Sindane. Further, the contract did not have the names of the stadium at that stage, but then she arranged with Saul Plaatjes. So the sixth and the fifth respondent then indicated that the fourth respondent has done this before, and they are in a position to have built these tracks at later on at the Saul Plaatjes municipality. And that's also why she then entered into the agreement with the municipality with regards to these tracks, because she was always under the belief that the fourth respondent will be in a position to build the track. Because my lady will also see at paragraph 10 of her answering affidavit, she specifically said, I appreciated the opportunity to work with Sibanda and the NLC in order to provide sports facilities, community and youth development. However, I indicated to Sibanda that everything must be good. Okay, then she went on to document it and account it. So for her at that stage, she was comfortable to proceed with that because there were people with the correct knowledge to assist her. And for her, it was about the development of the community and the youth.
Thank you. I don't know if you want to add any comments to just on that aspect, Mr. Pistorius. If you have anything you want to comment or say, that's fine. If you don't.
Yeah, thank you. The only submission I will make that there's a factual dispute regarding the contents of that submissions leveled by the deponent, the second respondent, with my client, Mr. Sibanda, the fifth respondent. So the court will have difficulty in adjudicating this factual dispute on the papers. But for my client's explanation in his answering affidavit and later replying affidavit with regard to how he met the second respondent and what was the terms of the agreement and the like. The second, the fourth respondent and fifth respondent also in their papers showed that the second respondent was in any event not allowed to pay over more than, contractually allowed to pay over more than 10% of the grant, which in itself is contradictory to the decision made out of her own accord, that is by Mrs. Koza, to transfer the monies to the fourth and fifth respondents. So that is as far as I will take that submissions. So to sum up, there's a factual dispute under oath which cannot be adjudicated on the papers. And that is one of the issues that I'll also raise later with regard to the manner in which this relief was sought. The applicant had to foresee factual disputes and the like, but decided to call on motion court proceedings to move this application.
Thank you, Mr. Paslele. Do you want to say anything?
Indeed so, my lady. My lady, first and foremost, there is an endorsement letter by the Athletics South Africa. In the endorsement letter, and that endorsement letter is G003, G003. In the founding papers, wherein Athletics South Africa says endorsement letter, building of an athletic track and field facility in Northern Cape. It says this serves to confirm that Athletics South Africa fully endorse Inqaba Yokulinda MPO to manage and coordinate the building of an athletic track in the Northern Cape. Inqaba Yokulinda is involved in assisting with the development of social oblivion community within the borders of the Northern Cape. Management of Inqaba Yokulinda is stable, reliable, and accountable. Inqaba runs a transparent, credible community project. I strongly recommend that Inqaba as a reliable partner. Now, they don't have any experience in the building of tracks, but they get an endorsement from Athletics South Africa, and that endorsement is from Skosana. And that endorsement is provided because the person that provided that submitted the application to the NLC is Magogodela, who works for the Athletics South Africa. Now, after the funds have been awarded.
So you say so Magogodela was instrumental in getting that endorsement letter?
In getting the endorsement. And now Audrey Koza wants to give the impression that she's innocent in the whole situation. But however, if one looks at it carefully, would understand that there cannot be an application submitted on behalf of your organization and you do not have sight of it and just accept the money. A responsible CEO or a responsible head of an institution would say, let me have a look at an application. And then you go on to continue and sign a grant agreement that makes specific references to what is supposed to be done. And you don't do what is been supposed to be done by the grant agreement that you have signed. You take 10 million thereof, you give it to somebody else and say somebody's supposed to do that, to build the tracks. And then you then come and say again that you take you on paragraph 20, with the remaining 3.5 million, we conducted a substance abuse program. The grant agreement does not provide for a substance abuse program. And the other point that I wanted to highlight, my lady, is something that I wanted to deal with it when I was when I was responding to my colleague Ms. Rustov, because she went even to say that after all we did not disclose certain information. There's certain information, of course, that we did not disclose because it has nothing to do with the remedy that we're seeking. Because here we're seeking a preservation order. More information will come in the review application. For instance, that there is an extra 4.2 million over and above the 15 million that was given to Inqaba Yokulinda. We haven't disclosed that because it's got all the facts that are here do not touch on the extra 4.2 million extra that was given, which was then used to build the tracks. So it cannot be said that when some of the information is not here, it was in bad faith. It was because the nature of the application itself is narrow. It was a preservation order pending the institution of a review application and the recovery. And to my surprise, even the respondents here do not disclose the fact that there was an over and above that a 4.2 million. They did not disclose that. But my submission here is that on the facts that are before the court, I mean the tribunal, it cannot be said that the first and the second respondent are very innocent. They know nothing about this, and that cannot be said. That is not consistent with the facts. How do you take 10 million the following day and give it to somebody else and say, we'll build the tracks? There is no contract, nothing. And say, give me give me an invoice. All that was interested is an invoice just to cover the tracks, not that they should build this thing. The tracks. They then utilize the remaining amount and applied for extra funding.
I mean, recover their tracks and not build the athletic tracks.
The 10 million was not intended for that. Yeah, maybe the extra, the remaining 5 million plus the 4.2 million, yeah. And lastly, there are conditions that were laid in terms of the grant agreement, and those conditions were never met. So if the intention was that they intended to do, they should have actually complied with the conditions of the grant agreement. That's my submissions on that point, Malidi.
Thank you.
Malidi, I want to deal with the first.
Okay, hold on, just give me a minute.
As the court pleases.
All right, thanks. That I just needed some input on that point. We will move on now to the application to strike out.
In reply there to my lady, I'll so start with the fourth and the fifth respondent, because that's their application, and the application, my lady, has to do with the following. There's a take notice that the fourth.
Well, shouldn't Mr. Pistorius start? He is the applicant. He's applying to strike out.
I thought he has addressed that. Maybe, my lady, if that is the case, then let me finalize my reply to Ms. Ristov, because I only dealt with the reply to Mr. Pretoria.
What reply?
The reply to the consideration.
Oh, you mean earlier on?
Yes, I didn't reply to the consideration application by Ms. Rustov.
I see you didn't. Yes, I see what you mean. You did not speak to the submissions made by Mr. Pistorius. Okay, good. Then I'll give you a chance to do that.
My lady, maybe there's also one other issue that I didn't address, the issue of agents. I think there's an issue of agents that has been raised under the consideration application. My lady, I think that has been overtaken by events in that this is a reconsideration application. And a reconsideration application, it implies that this tribunal is looking back at that application that we've made. And having looked at that application that was made, and then looked as to whether it should grant the orders as per the order of the 14th of February 2022. So the whole issue, whether this agency or not agents, that has been overtaken by events, and it's not necessary for this court to even deal with that. It has now become moot, because now the application is before this honorable tribunal, and that in itself it's sufficient to dispose of with the whole issue of agency. And moving now to reconsideration submissions by Ms. Rustov. She then dealt with the following.
Sorry, I thought you said you're done with the response. Did you? Oh, you started off with Mr. Pistorius, right?
Yes, I was finalizing Pistorius, yes.
Yes.
And then now I'm moving to Rustov.
Mm.
And in response there to my lady, Ms. Rustov indicated when we pointed out that there was no preservation order on any of the properties of the first and second respondent. He then said, no, we had to come to this court. I mean, to this tribunal, and the reason why we had to bring this reconsideration was because of the orders which were obtained ex parte. Specific reference, my lady, was made to paragraph 2.2. That's the first one. In the order of the 14th of February.
Mm-hmm.
And that paragraph 2.2 was to the effect that the first to the seventh respondents are directed to disclose the whereabouts of the preserved assets and any other realizable assets of the first to the seventh respondent acquired with the funds received from the cited respondents. Now, we all know that there is no disclosure that was ever made. We know that there is no realizable asset that was attached. So whether there's an order seeking a disclosure where you haven't made any disclosure, that cannot in itself be a reason for one to say, I would want this order to be reconsidered. Furthermore, my lady, it is a well-known rule of procedure that any other party that has an interest in the matter would have to be cited. But now, this order of 2.2 is limited only to the realizable assets and to the disclosure of the realizable assets. So there's nothing wrong with that kind of an order, and circumstances where the applicant is not aware of any other, if ever there's any other one, it makes now an obligation on them to disclose if they have them. If they don't have them, they have no obligation to disclose. That can be a reason for them to say they wanted to then oppose or to have the reconsideration of the order. Now,
just a minute.
There's the court, please, minute.
Mm-hmm.
As the court pleases, my lady, and further, my learned also colleague also referred to paragraph 5.1 as a basis upon which the first and the second respondent are defending the matter. This says, and 5.1 of the order made it very simple. It's about motor vehicles. It said within 7 days of the grant of this order, all motor vehicles belonging to the first to the seventh respondent, which are preserved. That's the first thing. And there's no motor vehicle of the first and second respondent that were preserved, and or disclosable asset must be delivered to the curate. There's nothing wrong if ever there's none, and there's not even allegations from the applicants to say there are any. We say, well, it's just putting only an obligation under the circumstances or the conditions that are laid down here. So that in itself cannot be a reason to have the whole order reconsidered. So the reconsideration by the first and the second respondent is ill-conceived, my lady. And for that, it has to be dismissed.
So if you say that just having that in there, if they don't have disclosable assets to hand over, then yes, it doesn't apply to them.
It doesn't apply to them.
Is that your submission?
Correct, my lady. Now, the other point that they're saying has to do with an order of cost.
Just one moment, Mr. Mpashlela. I just want to get that down.
Where's the court, please? They said that the other reason for opposition relates to paragraph 8.1. And they're saying that it relates to the issue of the cost, because they're saying this order makes it obligatory on them that they should pay the cost of the curator. But even that is also something that is very clear in terms under what circumstances. Because the cost of the curator bond is occasioned by or incurred in the implementation of this order as to be paid by the first and seven responding jointly and several. So if ever there are no costs that relates to the implementation of the order relating to the first and the second respondent, there is no obligation to pay costs. Having said that, my lady, then I would move to deal with another point. And I think I've touched on it briefly, which my learned colleague says that after the applicants did not disclose the material facts, been accused of not disclosing the material. And I think I've addressed that to the point where I indicated that the disclosure or whatever the material facts that are here are only as relevant as to the orders that are being sought. Because this is an application for a preservation order, or this is a reconsideration for the preservation order. It's got nothing to do with the review. The other facts will become disclosed when we make in the review, because it will then indicate as to, we'll have to account as to all the money, the 15 million, because we indicated that 15 million went to Inqaba Yokulinda, but the 10 million went to Unicas. And all the facts, material facts that are here are dealing with the 10 million. We've at no point dealt with the other 5 million, because the 5 million would not be of any relevance to the preservation order.
Yeah.
But then further submissions are to the effect that the second respondent is the one that approached the Hawks, MPA, the SIU. My lady, the SIU is established in terms of a proclamation. And that proclamation was issued in November 2020 to investigate the maladministration relating to the way the funds or the administration of the funds in the NLC. I find it very strange that Koza can then come and say, no, I approached the SIU, because the SIU only started taking action when it has a proclamation, and that proclamation gives its powers in terms of what is it that it's supposed to do. And SIU is also not part of the Hawks. So if you ever approach the Hawks, it's well and good. That might be in relation to the criminal matter. It might be a good defense for them in the criminal matter, but not for the purposes of these proceedings. The other point is that we did not inform this tribunal that the project was completed. My lady, we can only bring to the attention of the court or the tribunal information that is at our own disposal. If you don't have information, and we haven't gone there and seen that the project was completed and was in terms of the specification, we cannot, under oath, state those facts. So it cannot be said that for us not to state that fact that we're hiding information. No, it is not, because we don't have that information. All that we know is that after there was a further funding, and that will deal with it in the review, because the review application, it will be to set aside, and we've pointed out in the application, it will be to set aside the grant itself. Because we will be presenting evidence that it was not utilized for the purpose in which it was intended for, but not for the purposes of the preservation order.
Mm-hmm.
The further point, my lady, is the one that was stated that the impression that was created is that there was collusion. My lady, it is not an impression that was created. That is a fact based on the information that is before this tribunal, that there is a collusion. And that collusion stems up from the fact that all of us, there's somebody that is from that approaches the first and the second respondent, informs him, that is Sindani, and says, well, after all, there is this project that the CEO and the chairperson of the ANC wants you to help with. How do you get approached and say you want to be that you must help on something that we have no experience on? So, but that my lady, is also not for the purposes of the preservation, and I'm not going to delve much on that, because that is information that will be dealt with in the review application. All that we're saying is that after all, from prima facie, from what is before the tribunal, it points to collusion. Now, my lady, all the nice things might be said about the first and the second respondent by their representatives, fine. But as we sit here, there's nowhere wherein the first and the second respondent or any of the respondents are saying the 10 million rand that was paid to Unicas has ever been recovered. What is brought to the attention of the tribunal is that there was an acknowledgement of debt signed by Mr. Sibanda that he will pay back the 5 million. It's not even paying back it's not even paying the entire 10 million. It's paying back the 5 million. That was never recovered. And the purpose of these proceedings are to recover that.
Yes.
But well, your ladyship has been informed that, if it wasn't for the first and the second respondent, I don't know whether the applicant would not have known about the 10 million. But that cannot be correct. That cannot be correct. The fact of the matter is, there were applications that were made, and when there's an investigation, the investigator would go and recoup all the information from the NLC, would look at this grant funding. And one of that was for the building of the tracks. That investigation led to the investigation going to interview the second respondent. It's not that it was out of goodwill that she went there. If that she went there, this 10 million was paid in 2018. Why didn't she maybe long before the investigation starts then went and said no, I haven't got this thing, there's this 10 million that I've paid, I haven't built the track, take your 5 million and the other 10 million, go and get it from Sibane. No, they're not saying that. They take the 5 million and they take 3.5 thereof and use it for something else. That is not in terms of the grant. Whether they've used that or not is something else, because that will come out under the review application, because you'll have to come up and show us where the expenditure in relation to this other 3.5 million that they're making allegations of. But for now, it is not relevant for these proceedings, because we don't know where it went to, and investigation are still continuing in relations to that.
So you called her and arranged an interview. She didn't come to me.
And lastly, my lady, on this point, the interview was arranged by the SIU. She didn't call the SIU and say, I want to come and disclose this thing. No. I don't know, maybe I wouldn't blame her. Maybe she was not even aware that there was a proclamation. I don't know, I wouldn't blame her. But I just want to correct the fact is that it is not her. It was the SIU that approached her, and the SIU that approached all these other people, including all these attorneys and the banks that provided that information in terms of understanding where the funds went to. On that basis, my lady, my submissions is that the applicants have made up a case for an order consistent with the order of the 14th of February 2022, and that the application for reconsideration should be dismissed with cost, and those costs should include the cost of 2 counsel. Unless your ladyship would want me to address you on any other point.
No, that's fine, thank you.
My lady, my juniors bringing to my attention one other point. Let me just address your ladyship on. With the reconsideration application, my lady, that is before your ladyship and the ladyship is considering. What my juniors bring into attention, which I agreed to, is that in itself also renders that Rule 14 moot, because if you are before this tribunal for the reconsideration of an application that was made in February, then there was no need for the order to be extended, because once if the reconsideration is dismissed, then the period of the 30 days for the institution of the review application start running from the date of this particular order, because this is a reconsideration.
So now you're saying to me that we wasted a whole morning listening to the Rule 14 application. That's what you shouldn't have done in the first place.
That is what is being brought to my attention, my lady. And if one looks at it critically, that is a fact. Because if it's not a rule NISA, and if there was a rule NISA, then there would have been a returned date. But here, what happened was that there was an order that was granted ex parte. And that order that was granted as ex parte, we then got an application for the reconsideration thereof. So when you reconsider, then it means that after all, it now puts into question the entire application that was before, and for which the order of the 14th was done. And it renders then the Rule 14 application itself moot. My lady, those will be my submission, and unless there's any other thing in respect of the reconsideration, we submit that after all, the reconsideration application should be dismissed with cost, including the cost of 2 counsel.
Thank you, Mr. Mphahlele.
As the court wishes.
Thank you. Right. I think we're done with that application. We can now move on to the application to strike out.
as the court pleases, my lady, I
Mhm,
will
thank you.
endeavour to be and keep to the timeline that you have specifically ordered. It will be short. Respondents take offence to the inadmissible hearsay of the applicants, the opponent in the main application. My lady, we say that for the mere reason that in general, bank statements, documents, and the like were merely uploaded on Caseline without being properly sworn to, nor attested to under oath, having regard to the rules of this tribunal, that the rules of evidence is mutatis mutandis applicable in this proceeding. The opponent, Mr. Nkabeni, merely states that he has launched an investigation and that some of the allegations that he levels against the respondents that I represent is based on an interview inter alia conducted with the second respondent, Ms. Audrey Khoza. No reference whatsoever is made to the content interview, nor is a confirmatory affidavit at the time when the application was launched attached to these allegations. And it seems like the respondent now relies on the answering papers of the second respondent to try and justify that the hearsay evidence that they presented now becomes admissible. But I would respectfully ask that the arguments raised by the applicants that hearsay evidence is admissible in general terms and in vague terms in the interest of justice, in terms of Rule 4C of the Criminal Law Amendment Act, Act 44 of 1988, is totally baseless for the simple reason no factual foundation why the interest of justice would be served by hearsay evidence for you to make such a finding. What the respondents did is that we gave notice for the application to
Sorry, Mr. Pistorius, you're breaking up.
Duly served.
Sorry, I couldn't hear the last bit. You're breaking up.
The respondents, that is now the fourth, fifth, and seventh respondents gave notice to the applicants on 11 March 2022 of our intention to strike out the hearsay evidence purported in the deponent's papers. The applicant had ample time to remedy that, or at the very least, in a replying affidavit, address the issue of hearsay evidence, which they opted not to do. So in essence, we are submitting to your ladyship that large parts of the applicant's papers, based on Nkabeni's evidence, that is now the deponent, the main deponent on behalf of the SIU, is based on inadmissible hearsay evidence. It has no evidence, and it is inadmissible in law. It seems like my learned colleague for the applicant's argument is now that because Ms. Khoza has deposed to a statement under oath which corroborates inadmissible hearsay evidence, that they have met the evidential yardstick when they launched the application. That is simply not how the law of evidence works. If a party seeks to make amendments in motion court proceedings, which they opted yet again, and I reiterate that, they had to comply with the law of evidence, at the very least make affidavits and or confirmatory affidavits substantiating factual allegations, which they have not done. As a result, we submit that the respondents quite correctly, in following due process, invoke the provisions of Rule 28 of your tribunal and request that you invoke that, and that is the rules of the High Court, the rules of evidence, and as a result, that should award the application for striking out of the paragraphs consisting in the papers of the applicant, which we have stipulated. That is, in short, the submissions that we have to make pertaining to the striking out application.
Thank you, Mr. Pistorius.
Pleases.
Reply, Mr. Mphahlele.
As the court pleases, my lady, what my learned colleague submits that it is hearsay evidence relates to paragraph 12.1 to 12.4 and 12.12. And in the striking out application, they say that the entire contents should be struck off on the basis that where Ms. Khoza informed me that I received upon the receipt of the 15 million, she received a call from Sibanda to transfer the 10 million rand into the accounts of Unicas. My lady, I don't seem to understand why my learned colleague says that is CSA evidence, because we submitted that the investigator went and that is not and consulted with Ms. Khoza, and Ms. Khoza informed her about that. And now the basis upon which they were saying it was hearsay is because there is no confirmatory affidavit by Ms. Khoza to that effect. Despite the fact that there is no confirmatory affidavit, my lady, but Ms. Khoza deposed to an affidavit which in a nutshell substantiate all that was said by Ngobeni in the founding affidavit. So for my learned colleague to say now at the time that you stated this thing, there was no confirmatory affidavit. Well, I don't seem to understand that contention, my lady, because as long as there has been something under oath that now substantiates that, the tribunal cannot ignore that. It cannot ignore that at all. More so if one takes into the consideration the provisions of Rule 28(2), which even goes to an extent of saying that this tribunal, my lady, can even abandon the application of the rules of evidence in order to achieve the object of the act. But I know colleagues have not addressed that, to say, well, if he's now strictly relying on the principles of the High Court and by the principles of evidence as advanced in because he was referring to 28(1), but now Malene colleague said nothing about 28(2), which says you can even abandon that, my lady. So we submit that there's no merit, my lady, in that contention or the submissions that were made in relation to the hearsay evidence, and that the application for striking out should be dismissed, my lady, with cost and due the cost of two counsel. Those will be our submissions on that point, my lady. The other submissions have been made in our heads of argument. And my lady, the other point is that some of the contention that have been referred to is supported by the material evidence that is before this tribunal. For instance, the fact that there was about 10 million that was paid into the account is supported by bank statements to that effect. Unless they say they have an issue with the statement, they should have indicated that. So my lady, we submit that after all the application has no merit and it should be dismissed with cost into the cost of two counsel. Those will be our submissions, my lady. As the court pleases.
Thank you. All right. I think that's done with the application to strike out.
Sorry. May I just reply to that argument of my colleague?
Yes.
Hey, if bank statements is uploaded on case lines without sworn affidavits confirming the correctness and authenticity of the statements, then it's not evidence. and it's then hearsay evidence, and it's inadmissible, my lady. If my colleague says, as he formulates it, my lady, well, something is under oath. The question is, what is under oath? The opinion of an investigating officer without any evidence, and the rules of evidence applying particularly to this tribunal's procedure. It seems like my learned opponent regard the rules of the tribunal to be willy-nilly ignored when it suits the applicant, and that is not to comply with the law of evidence, and ask you in his answer to this application to ignore basic rules of evidence in any. At this tribunal,
sorry,
Mr.
Pistorius, you're breaking up quite badly there. I got as far as hearing that he wants the tribunal's rules to be ignored when it suits the applicant, and then I couldn't hear after that.
Yes, that is a submission, and have no regard to the law of evidence as is specifically made provision for in the rules of the tribunal. To allow that with respect would make a mockery of this proceedings, and particularly the manner in which this very stringent relief, which was sought and given against parties who were not even before court, was afforded. And with that, I will rest with respect and ask that the application for striking out will be upheld with cost of to counsel with respect.
Thank you. All right. I think we're done with that now, aren't we? Can we now move on to the rescission application?
So, my lady, the rescission application is brought by the 7th respondent for the crisp reason that she was a party against whom an order was sought and given erroneously so in her absence. We respectfully dealt extensively with this part of this application on page 6 and further on of the heads of argument of the 7th respondent, where we state that it is very clear that, and to assist your ladyship on page 6 of my heads against paragraph 21, that the order granted on 14 February 2022 was clearly granted against the 7th respondent in her absence. It follows that if that is so, and we referred you to the proper authority in that regard, that if a order was erroneously sought by the applicant and which error appears ex facie the record of proceedings as follows, I must reiterate against paragraph 25 what is the common cause facts. On page 7, 25.1, we say, the issued papers commencing the application was signed and issued by the Special Tribunal on 3 February 2022. In paragraph 25.2, in terms of prayer 1 of the notice of motion, the matter is to be dealt with on an urgent ex parte basis without prior notice to the 1st to the 6th respondent. 25.3, page 8. Prayer 2 of the notice of motion again only referred to the 1st to the 6th respondent, as do prayers 24.1, 2, 3, 4, and 5, 3.112, and the like. It is all listed in my heads of argument.
Yeah. I think the papers are quite clear what your case is,
yes.
and also it's set out in your heads. What I'm just asking is, where you have an ex parte application, can that be regarded as a default judgment where rescission would apply?
we do not argue that it's a default judgment. We argue it's a final order that was erroneous and given, and it properly construed with reference to the authority that I referred to you to. If an amended notice of motion was not issued by the special tribunal, there is no proper order upon which.
Sorry, Mr. Pistorius. Hello, sorry, you're breaking up again.
We say if the amended notice of motion, which was merely uploaded and not issued by the special tribunal, the order that follows on that is not a proper order, and as a consequence, it was erroneously sought and granted. So the remainder of the arguments of the respondent in this regard, as far as I'm concerned with respect, and that is our submission, would mean that the subsequent judgment was erroneously granted. It constituted an irregularity in the proceedings and was not legally competent for the Honourable Tribunal to have made in the first place. So, as a result, we submit that, and that is which I will in finality then conclude, that the order sought against the seventh respondent was erroneously sought ex parte on an urgent basis whilst she was not in front of court, and the mere fact that she was not afforded the opportunity on the Rule Nizai return date, that having found herself in the position of a final order is irregular and should be rescinded as we play in the notice of motion. So in the light thereof, and I've stated and I've referred to extensively to the authority, that the order was without any doubt erroneously sought and so granted, and as a result we submit that this application for rescission should also be upheld with costs, including costs of to counsel. That is our submissions, my lady.
Thank you, Mr. Mphahlele.
As it pleases the court, my lady. My lady, the applicant didn't bring two applications. He didn't bring an application for which he obtained a default judgment and another one wherein it was brought ex parte. There was only one application. And in the very same one application, the seventh respondent decided to say, now what I'm going to do, I'm going to, instead of going the reconsideration route, I'm going to bring an application for default, for rescission of a default judgment. And your ladyship has inquired from a learned colleague as to whether an ex parte application itself constitutes a default judgment, this order that was obtained. He said no. But if one looks at the notice of motion of the seventh respondent, it says that the default judgment or order granted on the 14th of February 2022 against the seventh respondent in the main application under case number GP01 of 22 be rescinded. Now that my learned colleague has considered that the order that was obtained was not a default judgment, that's the end of the matter, my lady. That is the end of the matter, because why should this tribunal be bothered in considering an application for a rescission of what is not a default judgment? Default judgment are dealt with in terms of section 22, and it is very clear that a default judgment is where the defendant or respondent, as the case may be, remains in default of filing a plea or a notice to oppose and answering of it as the case may be, and the register may, on notice to all parties, enroll the matter for judgment by default. This application that was brought was not brought in Rule 22, it was brought in terms of Rule 24. So there's no merit in the application for the rescission, my lady. And the application stands to be dismissed with cost, my lady, including the cost of 2 counsel. I have no further submission in respect of that.
Well, what I'd like you to address me on is this issue of the amended notice of motion not having been served on the seventh respondent, and that therefore the subsequent order that was granted, and if it was granted in terms of the amended notice of motion, was erroneously sought and granted because there was not proper service upon the seventh respondent. Perhaps you could just address me on that point.
My lady, the application was brought ex parte. And ex parte application, there's no need to serve the respondent. The respondent will be served after the order has been obtained. The reasons as to why the applicants approached the tribunal ex parte were dealt with when the ex parte application was heard. And if the tribunal at that point was of the view that the respondent should have been served before the application has been heard, that the tribunal would have indicated that to say, I'm not going to hear this ex parte application until the service on the respondent. And my lady, the issue of the amended notice of motion, it is an amended notice of motion because it was amended after there was a directive by the tribunal to say there are certain prayers that you are seeking that I'm not intending to grant, and these prayers in themselves would relate to the following prayers. And on that basis, there was a need to then amend the notice of motion to be consistent with what the court is willing to grant. And on that basis, that in itself does not amount to a default judgment. And because it's not a default judgment, it is a judgment obtained ex parte, for which the respondents now have the opportunity today to challenge the entire order that was granted on that day. And that's the purpose of today, to look into that and say, is there any other thing that was granted that shouldn't have been granted? Hence the reconsideration. So it's I find it very, very strange, my lady, that the very same respondent that are represented by one representative in respect of one issue, they bring a reconsideration, and then in respect of the other one, they bring a rescission. Why there's only one application before this tribunal? There are not two. So one application cannot be a judgment ex parte and at the very same time a default judgment. That can be.
So if I understand you correctly, the amended notice of motion was uploaded onto the system after the grant of the order.
No. After a directive was issued, that there are certain orders that you are seeking that I'm not willing to grant.
Okay.
And then we amended the notice of motion to deal with only those aspects that the SIU was willing to grant. There were a number of other issues that were taken out of the notice of motion if one compares the two. Hence, at some point, I think I made reference to a paragraph that I said it was 12, and then it became only to find that it was 11. Because there was some of the prayers that were taken out of that to and they were granted in terms of the amended notice of motion, because the court indicated that I'm not willing to grant this order and that order, and then we then amended our notice of motion to be in line with what we could be able to obtain. As the court pleases.
But the allegation, as I understand it, is that the original notice of motion was served on the seventh respondent. They did not see the amended notice of motion. That's what I just need some clarity on that.
My lady, I think what they were saying is the notice of motion and the judgment or the order, my lady, in terms of Rule 24, must be served after we've obtained the order. It must be served on the respondents. So I think what they're saying is that when that was served on the respondent after the order was obtained, ex parte, they're saying they were served with a notice of motion, the original one, not the amended one. I think that's what they're trying to say.
Yes, that's exactly what they are saying. That they did not get served with the amended notice of motion. It was simply uploaded onto the case line system.
My lady, there was an affidavit that was disposed there by Zondi that indicated that is it Zondi? Zondo. Yeah, that indicated that all the respondents have been served.
I'm not sure if I've seen that affidavit.
My lady, let me just check that.
And who is that person now that deposed to that affidavit?
My lady, that would be the attorney, Stella Zone. My lady, I'm just trying to get to that. It should be under proof of service. My lady, even if
Yes.
I'm trying to.
SC. Okay. It was Rulani Baloyi who attested to the service.
My apologies, my lady. I'm told it was Rulani Baloyi. Rulani Baloyi. That dealt with the issue of service. And my lady, I'll make that available. I'm trying to get it quickly from the case line.
Just be sent to my secretary, please.
I'll do so, my lady. Rulani Baloyi. That
You have her email address?
No, I don't have that, my lady. Can I get that?
Yes, it's ladams.
ladams.
@judiciary.org.za.
I got that, my lady. So the issue of service was dealt with that by Rulani Baloyi.
And she says she uses Jabusiband's email that must be served on the
When was that affidavit deposed to? You see, I'm just trying to get some clarity, because what Mr. Pistorius is saying is that the original notice of motion in which you say there were certain prayers which the tribunal at that stage said it would not grant, then you had to amend. Now, he says that the original notice of motion was served on them, not the amended one. Can you perhaps throw some light on that?
My lady, my understanding was that all the respondents were served with the order and the same papers. And the seventh respondent, in actual fact, my lady, said that the affidavit should be served on the email of Jabusibanda. So she was, if Jabusibanda was served with all the papers, she was served because she's the ones that requested that the email of Jabusibanda be the one that is used to serve her.
Yes. Okay. All right. That all, Mr. Mphahlele?
My lady, that would be all. I think I've dealt with the issue of the expert card, even which there is also raised this year. I don't want to repeat myself. That would be yeah, and we submit that. There's no merit in this rescission application that is tends to be, dismissed with costs, including cost of 2 counts, as the court pleases, my lady.
Reply, Mr. Pistorius?
My lady, thank you. My reply is short and sweet. My learned friend is wrong. The notice of motion, the original one dated 3 February 2022, was duly signed by the Office of the State Attorney, and it was served on the 7th respondent. Subsequently, the amended notice of motion was simply uploaded onto case lines on 9 February 2022 that never served on the 7th respondent. Accordingly, the amended notice of motion was not issued by the Special Tribunal, and that is the end of the matter, as the court pleases.
Thank you. All right, gentlemen. I think we've made good time. I'm going to reserve my judgment in each one of these applications, and you will be notified as soon as the judgments are ready. Thank you. And thank you, Ms. Ristoff, for so patiently sitting through the afternoon's proceedings, even though they did not concern your clients.
No, it's no problem, my lady.
Thank you so much. Then with nothing else to discuss, apart from ensuring that those missing documents all reach me, I'm sure Mr. Mantana is going to ensure that those come, and then you will send the service affidavit to me as well, Mr. Mphahlele. Thank you. Thank you very much. Then I suppose I should say, don't know whether I should say court adjourns or the tribunal adjourns.
Have a good week.
Thank you. Thanks very much. We will adjourn.
Have a good week.
Paragraph. Let me just.
When was that affidavit deposed? Afternoon's proceedings, even though they did not concern your clients.
No, it's no problem, my lady.
Thank you so much. Then with nothing else to discuss, apart from ensuring that those missing documents all reach me, I'm sure Mr. Mantana is going to ensure that those come, and then you will send the service affidavit to me as well, Mr. Mphahlele. Thank you. Thank you very much. Then I suppose I should say, don't know whether I should say court adjourns or the tribunal adjourns.
Have a good week.
Thank you. Thanks very much. We'll adjourn.